kind leave to mention, my lord, last week, my lord, written notes in a matter has been filed, my lord. But my lord, arguments in the matter has not been commenced, my lord. The matter has been posted as CAV, my lord. I'd be failing in my duty, my lord, if I do not indicate this to this honorable court, my lord. Although the written notes have been filed, my lord, but none of the parties have made argument in it.
Which matter?
My lord, FMA 1133 of 2024, my lord. On 12th of August, your lordship.
Railways matter.
Railways matter, my lord.
You did not appear, sir.
My lord, I was not present that day, my lord.
Then why are you saying
No, my
something
lord,
which is contrary to what has happened?
No, my lord, I was a bit.
Despite several dates being given to you, you did not appear.
No, my lord, no. Only on the last date, my lord, there was a direct.
Prior to that also, you did not appear.
My lord, I had appeared in the.
Sir, in the morning, first matter, let's not get into all these things.
My lord, may only indicate this, my lord. I will not.
You should fairly submit that you were not present.
On the last date, my lord, I am.
But you cannot say that there was no hearing and whatever you just told now.
My lord, may I just indicate one thing, my lord? My lord, if
your submissions must be fair, sir.
My lord, I am, my lord. I am making fair submissions, my lord. On the last occasion, there was a direction for, my lord, filing of written notes.
People will not come on the date fixed.
My lord, I apologize. My lord, only on the last date, my lord, there was direction for filing the written notes, my lord. Now, I was only beseeching, my lord, your arguments in the matters can be taken, my lord. Only on the last date, my lord, there was a direction for filing the written notes, my lord, and only on the last date I was not present, my lord. On the previous occasions, my lord, your lordship was directed to file as the written note, file the written notes, my lord. In compliance of that, my lord, on previous date we had filed the written notes, my lord. But neither the appellant nor the respondent had made arguments in the matter, my lord.
So why don't you appear on the dates fixed?
My lord, only on the last date, my lord, when there's a direction for filing the written notes, my lord, I was ill, I could not appear, my lord. My lord, I was only beseeching if your lordship could kindly take arguments in the matter, my lord.
But I will expect you to make fair submissions rather than, deviating from what is the exact situation.
I'm extremely sorry, my lord. I last day could not appear.
Mention for correction to be mentioned.
Lordship, may I be permitted to mention here for inclusion in the list?
What is this matter?
The matter was filed on 3/10.
What is the matter?
The service matter, WPA.
Have you served notice?
No, Lord.
Serve notice and then come.
Group 6 matters.
Have you served notice?
You have me. I have me.
My lord, may I have lost the ballot, one matter for correction and one matter for direction for finding.
Lordship, Group 6 matter, 2 matters for inclusion in the list. For
Have you served notice?
For inclusion in the list of the appeal. Applications.
I have the Lordship's leave to mention one matter for inclusion in the list. Grateful, my lord.
Your Lordship, may I have your Lordship's leave to mention one MSc appeal and applications along with it for inclusion.
Number 1 and 2.
One has been, Mr. Singh is appearing in this matter, my lord. It has been disposed of. Correction. They have
This appeal has come at my instance. For
whatever correction is there, please mention.
Mention, all.
What is the correction to be done? Is it a type?
Your lordship kindly.
Corrections, if it is there. Corrections, please come at 2 p.m. Not just early, just at the first sitting. Next. Sir, you indicate at 2 p.m. whatever corrections you have. Correction. What is it?
For enhancement, answer 163A. Now, paper that supplement it should be shall be disposed of.
Paper book filed by the learned advocate representing the appellant claimant, serving a copy of the same upon the learned advocate representing the respondent insurance company be kept on record. Can it be disposed of?
Let it fix the forward any day.
Heard the submission of learned advocates representing both the parties, let the matters be fixed on 12th of November for orders. Next.
ये तो है আগের দিন তো কারেকশন হলো আবার কেন এসেছে respondent correction last occasion one correction was made on the
কিসের জন্য এসছে স্যার? Department has given a note that no such corrections need to be made in the judgment. It's all right. No order needs to be passed. Next. Five, my lord, this is, if I'm post of my lord.
My lord, I am for the respondent insurance company, only a small correction, my lord. Only the name of my learned senior Rajesh Singh will come under respondent number 2 and my name will come in respondent number 1. That's it.
Grateful, my lord. Next.
my appeal my lord for dismissal of my claim 166 injury case amputation of leg my lord dismissed by learned tribunal.
You serve notice and come.
I serve notice my lord I shall take information.
The learned advocate representing the appellant claimants is to serve a fresh notice upon the respondent insurance company intimating the next date of hearing and file an affidavit of service to the effect. Next date be fixed on 14th of November. Next.
My lord, kindly have a look, my lord. Only mistake is, my lord, 1002, my lord, has been missed. You lordship kindly see the ordering portion, the assessment portion, only 1010. It is the lordship to the order.
P10.
My lord, your lordship kindly see, my lord, the medical expenses. My lord, kindly come to the assessment. Medical expenses 12300. It should be 30. And my lord, then my lord, pain and suffering 25,000. It's my lord 2,500. All are right.
এখানে একটা জিরো হবে, এখানে একটা জিরো হবে।
Is
For the petitioner appearing for the first time, deposited the statutory amount, praying for stay, my lord.
It's filed within time?
My lord.
The report of the stamped reporter mentioned the appeal to have been filed within time and in proper form. Let the same be admitted. Four weeks.
My lord.
Serve notice, file affidavit of service.
Deeply obliged.
11th of November. Next.
But I am for the petitioner in this matter.
And I am for the CST led by Mr. Sen, my lord.
This one. Well, this was initially a substitution application I had filed because the original petitioner has passed away, and his only son and wife have made application for substitution.
But in the substitution application, there was one inadvertent omission, that how they are interested in this writ petition was not pleaded. So therefore, my lord, I have filed an amendment application. That is CN4. And 4. And my lord, paragraph 15A is the relevant paragraph.
Of CAN 4,
CAN 4, my lord.
paragraph
15A. Page 17, my lord. I have annexed a proposed amended application in that paragraph 15A.
Chanchal. Do you have any objection?
No objection, ma'am.
The learned advocate representing the petitioner submitted to have filed an application being CAN 3 of 2025 and a further amendment to the same, the application number CAN 4 of 2025, which intended the present applicants to be substituted on the occasion of the death of the petitioner on
My lord,
death of the petitioner on
my lord, I'm telling your lordship. The death certificate.
have you filed the death certificate on 8
My lord, death certificate has been annexed to the application. It is on 8/2/2021. 8 February 2021.
further submitted that the applicant number 1 was entitled to the family pension and other service related benefits, and accordingly the substitution of the present applicants was necessary to proceed with the hearing of the instant writ petition. Full stop. Heard the submission of learned advocate representing the petitioner. The learned advocate representing the respondent did not object to such substitution. Full stop. Department is directed to amend the cause title of the writ petition by substituting the names and address of the present applicants as petitioner. Two are there.
Two.
Petitioner number 1 and 2.
And my lord, since the pleadings are complete, if your lordship kindly takes up this matter for final hearing in a subsequent date, my lord, because pleadings are complete in this matter.
পাতাটা কিভাবে ছিঁড়ে গেছে, এটাকে সেলোটেপ দিয়ে এই অর্ডার শিট এখানটা সেলোটেপ লাগে।
কি বলুন?
Next date be fixed on 12th of September for hearing.
I'm deeply obliged, my lord.
দুটোই
12
dispose.
September.
Thanks.
For orders, not for orders. What we are doing. I'm deeply obliged.
I'm appearing for the CISF.
Yes.
Well, hearing was completed in this case.
Today, date is fixed for clarification.
Now they have said that there must be a video footage. Yes, sir.
Madam,
So why didn't you keep that video footage?
But that That question was not asked during the inquiry. And moreover, my lord, this is the personal information data of the present petitioner. He was awarded 7 punishments.
So these are not
Even
included in
two
the
cases
charge
are-
sheet.
Even 2 cases are pending before your lordship.
But this data, these are not included in the charge sheet. They want to take, they want to consider those.
This is the
they
different
have to include in the
proceedings.
charge sheet.
This is a different proceeding.
You mean to say of the same petitioner?
Same petitioner, my lord. 2
No,
cases
that-
are still now pending before your lordship. Monikansi.
With concerning other charges framed against him
Yes, ma'am.
on other occasions?
Yes, ma'am.
The charges are same or
No, my lord.
different?
Charges are different. In all the occasion, my learned senior friend is the advocate on record of the petition.
This is first time coming, my lord. Give me a copy. Achha. That should have been included in the charge sheet.
I had this query only about that video footage.
My lord, all
So
the
do you, now they have said that video footage was not preserved. So now for every occasion, do you conduct any such proceedings?
No, ma'am. No.
You do not.
No. On the basis of the statement of the witnesses, my lord, judgment was passed.
Okay, sir. এটার সাথে এটা hearing concluded. Save. Next.
Lordship 13, I am acting on the private respondent 1 to 3.
For the petitioner, your lordship. Lordship, on the last occasion, there was a direction to serve on all the respondents. There are 4 respondents. We've served on 1, 2, 3, but on 4, we haven't been able to serve, your lordship. So I'm praying for a week's accommodation. If I could get your lordship, then I would be able to serve respondent number 4, your lordship.
Who is respondent number 4?
The cooperative, your lordship.
So what prevented you from serving them?
Lordship, due to certain difficulties, your lordship, I wasn't able
What
to.
difficulties? If you can serve, if you could serve upon 1, 2, and 3, so why not on 4? You are appearing for?
I am a private respondent 1 to 3. Lordship, mentality of the writ petition is under challenge because the dispute writing with the petitioner is challenging the order of dismissal passed by the private respondent, wherein that's exclusive domain in under the ID Act, Industrial Dispute 1947, wherein the tribunal and labor court has the jurisdiction to take up the matter. So further, he is challenging his dismissal order. Inquiry was conducted when he is found to be guilty of charges. This is our case before this.
Now the petitioner was working under which department?
The glucomide health.
He was working under the Gluconate Health India Limited, the respondent number 1 and 2. And there was some defalcation of the fund, and wherein the inquiry was conducted.
Which post?
He was as a clerk. He was working as a clerk. I believe we have also filed our short notes of argument because the matter was taken up on the earlier occasion also.
Pleadings are complete, your lordship, in the matter.
Earlier occasion means not by this court.
No, not by this, but by the Honorable Justice Ravi Kishan Kapoor. So it was hard at length, but matter couldn't be disposed of. So now we are before your lordship.
So the presence of the society, the cooperative society is needed.
It is their case, my lord.
Why have you implemented them as a party?
Mr. Rai Mukherjee, Your Lordship, is the advocate on record, Your Lordship. He's briefed in the matter. I'm just Chamber Junior, Your Lordship. I don't have.
So you don't know anything about it. You have
Come
just
free-
come to say whatever you have been taught.
Lordship, he's on his leg before division bench, Your Lordship. If I be,
Him to come.
shall Your Lordship. Lordship, kindly passes over the matter in that case, Your Lordship.
Lordship, can it take it on tomorrow, my your lordship? Can it be on?
You need not be present. Just
No, I will be there, obviously.
Great.
My lord, this matter, my lord, it was
Field limited matter.
this matter, my lord. Mr. Mahapatra has already concluded his argument. I was making my argument before your lordship on the last occasion, my lord.
No,
Your
what,
lordship.
just 1 minute, 2 minutes. My lord, in the opposition, there is nothing that the son-in-law of the employee
He will say,
cannot get the
the
appointment.
reply. No, I have not completed.
My lord, their only issue is that he is not the son-in-law. Vigilance, they are vigilance race. Matter on behalf of the respondents, police was asked to investigate. SP has given a report that he is the son-in-law of the petitioner. Other authorities also given that he is the son-in-law of the petitioner. Yet the matter was kept pending. My lord.
okay, sir.
No, my lord, that's why I was telling him that please you give it, say it in reply, because when he says something, he must show it from the pleadings.
Okay,
This is
sir.
one.
You
And
start.
the second thing is, my lord, on that earlier occasion also he raised this point that we have not raised this issue while dismissing, regretting his claim. Now, what was the claim, my lord? Who is he? He is the son-in-law of the employee who got himself retired on the ground of medical incapacitation. It's not a case of death. Now, here we have taken certain points, my lord, that delay is one point, my lord. Delay is one of the point. Another is, my lord, that when there is a direct dependent under the NCWA, National Coal Wage Agreement, then the indirect dependent being son-in-law is not entitled, though it was not taken at the time of regretting his claim. But as it is in the NCWA and his claim is totally based on NCWA, he cannot blow hot and cold at the same time. He cannot say that I take NCWA partly and the other part I will not take. I will not accept that. He cannot. So that's my pleading. Well, that's my answer, reply to what he has said. Now, my lord.
Sir, you have been given chance. Now
No,
let
my
him
lord,
conclude and
just-
thereafter.
I'm hearing, man.
Yes. Now, my lord, on the earlier occasion, my lord, one I have given, my lord, probably, my lord, so far, because written notes of arguments are already filed, my lord. It's filed by both the parties, my lord. So I'm not troubling your lordship with much. If I say that in a nutshell, my lord, what had happened, it's just for a short recapitulation, my lord.
You will be referring to your written notes or the opposition?
Written notes first, my lord, if your lordship takes, because it's a concise form and it will say, my lord. Well, Nihal Gop was the original employee.
Yes.
Now, my lord, while he was posted at the Kenda Colliery, my lord, under the Pandavashar area, the said he applied for retirement on medical unfitness on 21st of November 1990. That's a very important, my lord, because why, my lord? I pause here for a moment. I have taken another ground under the NCWA. An employee can take advantage of this retirement on medical unfitness and get an employment for his dependent only when he has not completed the age of 58 years. It is under the NCWA. I will show it. Now, my lord, on 21st of 11/1990, he applies for the retirement on medical unfitness. Such application been considered. Now, by an office order dated 19th of November 1991, which is at page 14 of the writ petition, the said Nihal Gop service was terminated on the ground of medical unfitness with effect from 22nd of November 1991. So he applied on 21st of November 1990 and he was declared medically unfit and his services were terminated on 22nd of November 1991, at least a year after. So if I even take the doctrine of relating back, then also his claim or his services were terminated, he may claim that his services were terminated should be reckoned from the date of his application at the best, my lord. So at the best it could be 21st of November 1990. Now what happened thereafter? My lord, the date of appointment of Nihal Gop was 1/1/1958 and his due date for superannuation was 13th of January 1992. 1992. And when did he make the application? 21st of 11/1990. So he had already completed the age of 58 years. It is not in dispute. It is not in dispute. Now, well, let's keep up all other things, my lord. Nihal Gop, my lord, if your lordship kindly turns to page 2 of my written notes, my lord, point number paragraph 6, Nihal Gop died on 8th March 2006. Kindly see, my lord, when did he? When was he declared as the services were terminated? 22nd of November 1991. He died on 8th March 2006 at his native place in Bihar. It is only after the death of the said Nihal Gop that the writ petitioner claiming himself to be the son-in-law of the said Nihal Gop claimed for employment. It is not a case, my lord. I repeat, my lord, it is not a case that employment was sought for against death of the employee. If that be the case he runs, then there is no scope of any employment at all. At the threshold it goes because he ceased to be an employee. So it was a case he runs that on the ground of medical unfitness, he was declared, he was retired, and on that ground he claims. So when the claim was made, about 15 or 16 years after that retirement. So this is a first ground. There is a delay. Now, there is no explanation to that. Why? ECL, however, ECL did, my lord, thereafter, my lord, all this, whatever the processes are, ultimately ECL, my lord, regretted it. The claim for certain documents and many things, and Vigilance Department also gave some documents, my lord, which is, my lord, I must candidly say, no document of the Vigilance Department is on record. I must say before your lordship, is on record. Well, we do not have even that document because we wrote to the Vigilance Department also. A personnel department and legal department who looks after the matters wrote to them, but they could not provide any document right now. Now, Vigilance Department report was that he was not the son-in-law and all these things. So it's something determined. I'm not going into it because if I cannot substantiate that thing without the document, there is no profit in making submissions on that. So ECL regretted the claim on 3rd of November 2008. So which is at Annexure P9 at page 22 of the writ petition. Now, thereafter, my lord, 10 months thereafter, he filed the present writ petition. So, affidavit exchange, my lord. First, my lord, if your lordship sees the National Coal Wages Agreement, a copy, I believe, my lord, it's in your lordship's record. On the earlier occasion, I handed it up.
Yes.
Now, memorandum of agreement. This is the NCWA 5. As your lordship knows, that it is made after every 5 years. So at that point of time, NCWA 5 was in vogue. Now, what does it say, my lord? If your lordship comes to paragraph 9.3.0 first, it is marked as page number 38. It's an extract from that, the bottom. 9.3.0. 9.3.0. NCWA 5, my lord. It's an extract, my lord, from the NCWA 5, my lord. On the bottom, your lordship will find the page numbers 38. It's written 38, 9.3.0 clause. It says, my lord. No, এটা তো আপনাকে আমার দেওয়ার দরকার নেই.
Provision of employment to
It's a rule.
dependents.
Either you talk to me or allow me to submit.
Yes, sir.
Yes. Employment would be provided to one. Employment would be provided to one. First says 9.3.0 provision of employment to dependents. Then 9.3.1 employment would be provided to one dependent of workers who are disabled permanently and also those who die while in service. The provision will be implemented as follows. So it's the enabling provision, my lord, 9.3.0. It starts now 9.3.1. Now, my lord, I skip 9.3.2 and 9.3.3, and thereafter, my lord, 9.4.0. Employment to one dependent of a worker who is permanently disabled in his place. Now, first, the disablement of the worker concerned should arise from injury or disease, be of a permanent nature resulting into loss of employment, and it should be so certified the coal company's concerned. This is the first condition. There should be a loss of employment. Here it is, there is a loss of employment. The moment he was declared medically unfit and he was terminated. Loss of employment. This is fulfilled. Now, in case of disablement arising out of general physical debility, so certified by the coal company, so it is a general physical debility certified by the coal company, the employee concerned will be eligible for the benefit under this clause if he or she is up to the age of 58 years.
58 years has been.
Yes, on the date of his application, he crossed the age of 58 years. I will show once again, my lord. I pause here for a moment. I take your lordship back to that 58 years thing, my lord. If your lordship takes up my written notes of arguments.
Say his appointment was on 1/1/1958.
Yes.
And he
Yes.
applied on 21st of
November
90.
1990. So, my lord, I had given my lord his due date for superannuation was 13/1/1992. So if it is 1992, 13/1/1992, so 58 years completed, my lord, on because the age of retirement is 60 years. So he completed the age of 58 years on 12th of January 1990, and he made the application on 21st of
his date
yes.
12th of December, 12th of January.
Yes, my lord.
How can it be, sir? The date of appointment was on 1/1/1958.
No, age is 60 years. Age is 60 years. So date of superannuation was 13/1/1992. So
what should have been the 58 years of service or age?
no, 58 years of age. Once
So
again, if
what
you
is
lordship,
his date of birth? That is not mentioned.
no, I'm giving my lord. Yeah, your lordship will get it.
Whether it's 58 years of service or age.
That's
because here you have mentioned the date of appointment was
yes.
1/1/1958 and
Yes.
his due date for superannuation was
Yes.
13th of January 1992.
Yes, my lord.
His age is not mentioned. I mean,
My lord.
date of birth is not mentioned.
Date of birth is not mentioned here, my lord.
Without the date of birth, then how can you assess, sir?
So no, it must be in our. Let me mention it was transferred before me, my lord. Now, my lord.
Do you have his date of birth, sir? If you are entirely relying on his age,
Yes, yes.
then his date of birth is
Two things,
required,
my lord:
sir.
age and direct dependent and indirect dependent. Two
That's
things.
right. But first of all, his age must be there.
Yes, your lordship will get it, my lord.
From which document will
My
I
lord,
get it?
if your lordship takes up the affidavit in opposition, page 22, I believe. And another thing, my lord, lordship will get it.
Yes, my lord. Page 22, 11/9/81. Date of birth. 51 now.
No,
81. 51. There is their opposition. 11 September 1951.
Nowhere
Just a
the
minute, my lord.
nowhere in the documents that you have mentioned the date of birth or
Well, their opposition, page 22.
page 20.
Two.
Their
I
opposition.
said, my lord, page 22.
Column 6. Date of birth.
1. Is it 1?
11/9/51.
51.
951.
51. It's written as 81. It cannot.
951. So he had applied for retirement
My lord, it's also not clear, my lord. 11/9.
either whether 11/9 or 1/9.
No, not 1/9, my lord. It's 11/9. It's 5 is written like 8. 5 is written like 8, but it cannot be 8. 11/9
It is 5, my lord. It's 5.
No, it
Because
looks like
this is
8.
date
It
of
cannot be.
1974.
It cannot be 81.
No, it is 51.
51.
It is 51. It cannot be
81 cannot be 81.
cannot be 81. It's 5. That's clear. Either it has to be either it will be 1 or 4 or 11. 951 part is okay.
Okay.
Now, so he applied for medical retirement on medical unfitness on 21st of November 1990. So that is beyond if it was 1990. So it was below 58
It was
years.
below 58, but if it is taken that the age that when he's lost his employment, then it is after 58. Whatever it is, my lord, as your lordship takes it up. If it is the date was
below
1990,
58.
but if your lordship takes it when he lost the employment, because as per the NCWA, when he lost the employment, it was 1991. So it was above 58 at that point of time. And
So it
thereafter,
falls within that 58 years cap.
we say no. We say no.
Why?
Because he applied, thereafter certain documents were asked from him. He was medically tested, because without his medical test and all these things, it is not possible. And thereafter, we declared him unfit with effect from 22/11/1991, and he accepted it without any demur and protest. He didn't say so. No, it has to be given a
Now let's come
retrospective
to
effect.
the agreement part.
Yes. 9.4.0.
Yes, in case of disablement arising
But
out of general physical
prior to that,
disability,
my lord, one.
so certified by the coal company, the employee concerned will be eligible for the benefit under this clause if he or she is up to the age of 50. So it's up to the age.
Up to the age of 58
Yes,
years.
so he fell
My lord,
within.
it is to be read with clause 1. It cannot be read isolatedly. My lord, kindly read 1.
You should understand
Yes.
that first, whether he was eligible
Yes.
to have been retired
Yes.
on the ground of medical unfitness.
Yes.
So if we go to it, if we consider that, so he is coming within the purview of 9.4.0, 1 and 2. Right. Now you come to the dependency part.
No, my lord. First, let me clarify myself, my lord, for my satisfaction. It has fallen from your lordship, because 9.4.0, my lord, if your lordship says, it contains several clauses, but first two clauses, the order of the clauses. First is 1, which says when he will get the benefit the moment there is a loss of employment. It is the first part. So the intention behind this agreement, first, he is to lose his employment. There is a loss of employment. First. So there was a loss of employment, which date? In 1991. Thereafter it says, otherwise it would be just the opposite. 2 would have become 1 and 1 would have become 2. Otherwise, my lord, 2 would have become 1 or 1 would have become 2. But it's not that. First, there is a loss of employment and you are 58 years to avail the benefit of seeking employment. This is my submission, my lord. This is my submission. Subject to correction, whatever your lordship takes it. This is one part. Now, so far the second part is concerned, my lord. And there, my lord, I must say third part, my lord. First part was the delay. I have shown, my lord, I have annexed several judgments here. And
What did does this agreement
yes,
stipulate a particular time period within which one has to apply?
no, but there are several judgments also, my lord. As regards the compassionate employment and even as regards the NCWA, I have stipulated. And I believe, my lord, I have another recent judgment. Just now, it's not with me. It's Rourkela Industry. It's a very recent judgment which says, dear my lord, a person immediately after the death of the father, suppose he went and filed an application and immediately went to the court and he was fighting it out for 10 years or 12 years. Thereafter, that matter was withdrawn and he was given liberty. He again filed a case and that matter went up to Supreme Court, where the Honorable Supreme Court said, no, even though you are fighting it out, several years have gone, you have sustained yourself, you are no more in requirement of any compassionate employment. Here, my lord, I have annexed another judgment. So far delay is concerned, I have annexed and paginated it. It's Parthen Orao case. There also it was a missing case. So the coal company took the view or the point. Coal company took the point that no, it's a missing case, so it's not a death case, because you have got a decree from the civil court declaring the death of the employee. So NCWA does not say about any civil death. Court says no, you're wrong. It does not discriminate between civil death or a natural death. But
So the first application by the alleged son-in-law, according to them, was filed after 15 years. The first application was filed after 15 years.
Well, they are considering constitutional, come to page 16 of the writ petition. Onward, they are frequently asking for documents he is giving. No such issue was there.
So what was the date of the letter, my lord? Kindly.
They have acceded to the request. They are
What was the date of?
Sir, I asked you, when did you apply? You are showing their
my lord, that
letters.
is not here, my lord. Only they are considered reference applications. It happened the 22/6.
Your case, sir, rests only on one ground. Because they are covered by, irrespective of their status and irrespective of the date on which the application was filed. Nonetheless, their case is covered under the clause 1 and 2, right? Because the person concerned, he was declared medically unfit prior to the attaining of 58 years of age, and secondly, to have been retired also prior to his attaining 58 years. Now, immediately, whether 9.5 mentions the criteria.
No, 9.5 is different. It's not for female only. 9.5 is for the female only, my lord. 9.5.0.
9.5 onwards, I mean to say.
No, it's for the female dependent only. It doesn't apply to any male dependent. It's only in case of female dependent.
9.
It doesn't apply to
9.4.3.
Yes, what was the, it was the definition,
The
who are the
dependents
dependents?
for this purpose
Yes.
means a wife, husband, as the case may be, unmarried daughter, son, and legally adopted son.
Yes,
If no such direct dependent is available for employment, younger brother, widowed daughter-in-law, or son-in-law residing with the employee, almost wholly dependent on the
Yes.
earning of the employees
grateful,
may
my
be
lord.
considered.
I'm grateful, my lord. I'm grateful. I was about to read this clause. I was grateful.
So 9.5, I just saw the last clause, so it hit me that way.
Yeah, I'm
But
grateful, my lord.
this is the one which I am.
Yes, I'm grateful, my lord. I have 2 points, my lord. One is the
So
delay.
delay would be your
No, this is also, this helps me because there is a judgment that I have also annexed. Because at that time, when he applied, this petitioner, the wife
okay, sir. We'll conclude on the next day.
was alive. And I have annexed the judgments also here, my lord. I will show on the next day.
Heard the submission of learned advocates representing the respective parties. Next date we fixed on 9th of September for final hearing.
9th of September. Where is my lord? 9th, final hearing.
Next.
Yeah.
My lord, I am for the state respondents. That is respond number 1. In the last petition, there is a direction from your lordship, my lord, to file affidavit in opposition. Yes. Okay. Of opposition file.
But I'm tendering apology because the learned register of the Howrah judges was on leave. Today he has came, my lord, and we are affirming today. And we have, if you are kindly posted the matter next week, my lord. Today we are affirming, we will sub
Affirming what?
the lordship directed, my lord, to file in opposition. That is ready. The learned register went to the before the commissioner for affirmation.
Next.
Ashur. Who is for the petitioner? And who is for the state?
My lord, I am for the state. Respond number 1. My lord, respond number 2,
and you-
Mr. Galib is appearing along with respond number 2, that is backward class welfare department. And for the district judge, my learned friend is appearing. There are 3 respondents. My lord.
The learned advocate representing the petitioner as well as the respondents are present. You are respondent number 3. On the prayer of learned advocate representing respondent number 3, let the matter be fixed on 25th of August.
Only thing, my lord, whatever steps has been taken by the learned district judge, now, my lord, that has been done in terms of the direction and the order of this honorable court as well as direction passed by the, my lord, judicial secretary. Therefore, my state affidavit is also required. But if they have filed, my lord, I am just
Have you filed the opposition, sir?
So, my lord, I have instructions from the judicial department. My lord, the instruction says that the district judge is the chairman of any selection committee in respect of a particular district of the concerned judgeship.
This is
So, my lord,
concerning selection process.
yes. Now, my lord, selection process, since the district judge, yes, my lord. The chairman, the only thing subject to your lordship's approval, as indicated in my instruction, that after such selection process, regarding reservation procedure, the district judge may forward the file to the concerned judicial secretary, who will forward the same to the concerned backward class welfare department for their view. This is the,
Let us
my
first
lord.
see what is their opposition.
My lord, my lord, my lord.
And there are
Yes, my lord, if your
required,
lordship,
there will be a
yes, yes,
direction.
my lord, my lord.
হ্যাঁ দিয়ে দেবো।
Next.
25 তারিখ থাকবে, আজকে অ্যাফার্ম করে দিয়ে দেবো। গ্রেটফুল।
Lordship, and for the respondent, you are to kindly pass it to but once Short pass over, your lordship. Mr. Jidda is with me, he's coming, my lord. I'm deep level.
Next.
20 my lord, I have confirmed. In the last occasion also they did not appear. Your lordship was.
My lord, in this matter, I'm playing short passover on behalf of Mr. Indojit Dasgupta.
He has been engaged?
My lord, he's on his legs before court number.
Has he been engaged in this matter?
Yes, my lord.
My lord, I appear for the petitioner, my lord. My lord, kindly sees the order dated 30th September 2013 of Justice Dipankar Datta, as his lordship then was.
So you are representing the
Petitioner.
You had to file the death certificate.
Yes, I have brought it, my lord. Before that, I have brought it. But, my lord, they have complied by filing the report as inquired by Justice Dipankar Datta, why the case was reopened, my lord. That is also matter in question, my lord. It is to be.
Who is your other side?
Hello?
Who is appearing on your other side?
Yes. Mr. এই ম্যাটারটা চলছে 26 হ্যাঁ অনেকগুলো গ্যাপ আছে তো সরি অনেকগুলো নেই তো আচ্ছা
You're referring to which date?
30th September 2013.
30th September 2013.
13.
How many times did you get the matter dismissed?
Only once probably. So far, I remember.
It was made to go out of the list.
Not dismissed, but it was gone out of list.
So why, if you had been there, it shouldn't have gone out of the list?
The list, my lord. As old matter, we missed the list. We missed the list, my lord. That is the reason.
Sir, in 2019, comparatively, it was not the old matter.
My lord, kindly come to the order of Justice Datta.
Yes, what happened?
That, my lord, pursuant to this direction, my lord, they have filed a report, my lord. Kindly consider this report. Justice Datta's inquiry was what prompted them to reopen the case, my lord. Because, my lord, earlier, my claim was negated.
To obtain instructions as to how and in what circumstances the district magistrate Purulia reopened the issue of inclusion of the name of the husband of the petitioner in the list of land losers, despite his claim having been rejected on 4th of March 2003.
That referred to page 27 of the writ application, my lord.
What is it, sir?
This is, my lord.
My lord, this is a case, my lord, where my lord, the petition, that matter, my lord, the earlier occasion, that matter was, my lord, filed by the husband of the my lord, petitioner just before your lordship, my lord, and that has already been withdrawn.
The direction was passed to consider my representation. After considering the representation, DC magistrate was pleased to, my lord, reject my claim, my lord, on the ground that lesser quantum of land was acquired. But that is incorrect. They have admitted that his claim was that only 96 decimals of land was acquired. Actually, 1 acre, 12 acres of land, 1 acre, 12 decimals of land was acquired. That will appear from their admission, my lord, from their document. For that reason, my earlier claim was denied. But later on, my lord, from the page 27 of the writ application, it appears that they recommended our claim, my lord, for processing. For that reason, Justice Datta was pleased to inquire from them what prompted them to issue this, my lord, communication to consider my case. That was the inquiry.
My lord, however, my lord, that question does not arise at this present moment because my lord, the petitioner before your lordship is the wife of the my lord, person who has been my lord said to be recommended. My lord, he has my lord not been my lord before your lordship.
Who?
My lord, the petitioner who is claiming, my lord, this land has been taken and there is three my lord son of that person. My lord, one son, two other sons, my lord, gave a no objection, and thereafter, my lord, this law, my lord, the youngest son, my lord, applied. My lord, thereafter, my lord, the litigation started. Thereafter, my lord, as his law, my lord, there is a consideration order. That order, my lord, finally, my lord, once rejected, and thereafter that was considered. But in the meantime, my lord, leaving that, my lord, this application has been filed by the wife of the youngest son.
Wife of the younger son.
Youngest son, who was, my lord, who was there now saying that you do not give the son an employment, you give me the employment. My lord, on earlier occasion, my lord was pleased to direct them to produce the copy of the death certificate, which was, my lord, has to be produced before your lordship today.
This point is already over. That was considered by Justice Dotto. After considering that one, what the my lord objection is raised by my.
So where is the death certificate of the father-in-law?
I have brought it, my lord. But I have some submission to make, my lord, because my lord kindly sees their pleading. They cannot go beyond the pleading. They have admitted that our claim was negated on the ground that lesser quantum of land was acquired. That is the only ground. They cannot go beyond the my lord, pleading.
That,
kindly sees their opposition.
my lord, that
I am referring the opposition, my lord, sir. Kindly consider this.
For that, my lord,
So did you give any clarification?
my lord, what
I have not given
my
any
lord,
clarification,
my lord, why this, my lord, death certificate becomes necessary? Because, my lord, the admittedly, my lord, the acquisition was made after the death of the my lord, father of the my lord, father-in-law of this present petitioner and the father of the my lord, three sons.
No,
My lord, my lord, then, my lord, I have placed before your lordship the entire, my lord, the money has been divided into three parts and has been given to three persons. My lord, if the original person who is the owner of the, my lord, property is still alive, my lord, the three sons could not have got the, my lord, I have given
Have you filed the
yes, I have given the
opposition. Yes,
yes, opposition has been filed.
You have mentioned it in the opposition.
My lord,
Have you mentioned this?
that was probably not mentioned,
Not
my lord.
mentioned, my lord. That is the from the bar.
That is from the report, and also, my lord, from the documents my lord has
Now,
directed
sir,
us to place.
let's go one by one. You come to the 30th September order of 2013.
Okay, page. Annex করা নেই
30th September order.
কোথায় তার অর্ডারটা দেখানো আমাকে
Now, as he is saying that the file was reopened.
Yes.
So, what was the reason for which the file was reopened? Was it for further consideration or not?
That my lord, that is the first time it was.
Yes,
No, I have
it's
raised
in
this.
the year 2013. Thereafter, he has come up with this issue that you have not given an explanation as to why the file was reopened, which you had to, as per the direction of the court, by order dated 30th of September 2013. Number one. Number two, if at all you had considered their case, then who would have been the appropriate persons upon whom you would have conferred the benefit? These are two questions to be solved. So first of all, you find out, sir, as to why your affidavit in opposition doesn't mention that.
My lord, report, my
Does
lord,
it?
kindly, I have filed a report, my lord.
When?
That is subsequently.
When?
That is, my lord, kindly sees, it has been affirmed in কত তারিখে affirmed?
January 8th, my lord. It is
10
communication is of
September 2024.
Yes. What have you stated?
My lord, here, my lord, paragraph 10 and 11, my lord, is is very relevant. In compliance with the order of the, my lord, may I place it? In compliance with the order of the Honorable High Court passed in writ petition number such and such, the District Magistrate Purulia heard the parties on 14/2/2003 and on 4/3
Which paragraph are you
14/2/2003 and
Paragraph are you going
my lord, 10, page 5 of the report.
Yes.
In compliance with the order of the Honorable High Court, Calcutta passed in writ petition number such and such, the District Magistrate Purulia heard the parties on 14/2/2003 and on 4/3/2003. Wide memo number 182 LA, the District Magistrate Purulia passed a reasoned order where expressed his inability to recommend the case of job assistance and held that only 0.2869 acres of land has been acquired in connection with Ramchandrapur irrigation scheme for public purpose. For acquisition of small quantum of land, the main source of income has not been affected. The family of the writ petitioner has not been uprooted from the place of residence. The District Magistrate Purulia rejected the case of job assistance on the ground that ground of acquisition of very small quantum of land, as well as not fulfilled the condition as circular of the circular of Labour Department, Government of West Bengal. Thereafter, my lord, paragraph 11, the additional district magistrate had given the opinion and guideline regarding the employment of Shona Chatterjee, the petition before your lordship, for employment assistance on the land user ground arising out of WPA number 27397 of 2013 in the matter of Shona Chatterjee versus State of West Bengal and others, wherein it is stated that as per Labour Department letter number 565 EMP dated 8/8/1988, the petitioner is not fulfill the following criteria which is mentioned in the said letter dated 8/8/1988, that the main source of income has not been affected, the main family of the petitioner has not been uprooted from the place of residence for acquisition of such quantum of land as per Geo 301 EMP dated 21/8/2002 of the Labour Department, Government of West Bengal, Geo 3 dated 5/1/2005. The petitioner did not fulfill the criteria mentioned in the
Did
said.
they receive any compensation against?
Yes, compensation has been
Apart
received.
from compensation, my lord, there was provision for providing
So they are saying that the area of the land that
Yeah, an
has been
expression.
Yes,
acquired.
that is, my lord, from their document, it appears they have considered on wrong appreciation of material on record. They are saying that only 0.28 decimal of land was acquired, but actually 1.12 acres of land was acquired.
That is my lord, the total of the father-in-law.
My lord, land was acquired from the recorded owner. Recorded owner was, my lord, the father-in-law of this petitioner, my lord. So, my lord, they considered the land of my father-in-law. That is the total land of 1.12 acres, not 0.28 decimals, my lord. That is my lord, categorical submission. And that was not considered.
So you are agreeing that the entire plot was of 1.21?
1.21, but that has their father has already been already dead at the time of acquisition. My lord, I will place, my lord, the records showing that three sons has taken the, my lord, the compensation. So, my lord, if the father is alive, my lord, the question of taking of compensation by the three persons does not arise at all.
My lord, third generation may, my lord, receive the compensation. That does not mean that it was not acquired. My lord, it was not acquired from their ancestor, my lord. What he is submitting, that if anybody, my lord, receives the compensation, that will substantiate their claim that though they are the, my lord, owner of the land. That cannot be, my lord, considered, because, my lord, we are this second generation who received the compensation after the death of our father, my lord. So that does not mean that the land was not acquired from our father. Well, can we consider this?
They have not denied.
No, they are not denying that it was not acquired from my father, my lord. What they are, my lord, denying now, that they are apportioning the quantum of land between, my lord, 4 years. That cannot be done, because, my lord, recorded owner was our father. From him it was, my lord, acquired, and he was, my lord, they never initiated proceeding under LKS against the name of the sons, against the name of, my lord, my father. So they should, my lord, explain it why they have, my lord, initially negated our claim. on the ground of lesser quantum land, and now they are shifting, deviating from their earlier stand. Kindly consider their opposition. They never said that we have denied the employment to the petitioner on the ground of lesser than 1 acre of land. That is their own stand. That has been disputed by their own records. And consider the material on record.
You first place the death certificate of the father.
Yes, that I am placing, my lord. That is the death certificate. And it was initiated against the name of the mother death, dead owner, my lord. If they say so, my lord, that is the LA proceeding was, my lord, initiated.
This is the death certificate?
Yes, ma'am, that was granted by Gram Panchayat. That is the actual authorities.
What is this?
কবে দিয়েছে? Date of issue? This is, my lord, dated 30/11/2024. Whether, my lord,
29th November 2024.
কবে মারা গেছেন? 59 এ।
Yes, that is not disputed. But, my lord, the
my lord, whether, my lord, 70/71, my lord, this acquisition process has been made. So, my lord, 59, if a person died, my lord, can they say that, my lord, kindly visualize, my lord, my lord, thing, a land cannot be without any, my lord, owner. My lord, immediately after the death, my lord, according to the personal law, my lord, it devolved into the 3 sons. And they have participated in the proceeding, LA proceeding. They have individually taken the, my lord, compensation. To that effect, my lord, I have submitted, my lord, before your lordship, and I have given the copy to my learned friend also, my lord, that they have individually taken the compensation. Now, my lord, taking of compensation, they are taking individually. Now, after, my lord, at the time of employment, they are clubbing the thing together.
No, that is not correct. What my learned friend is submitting, my lord. My lord, it is not on record. What is the extent of land owned by my father, my lord? So, my lord,
it is not on record.
Not on record. That is the difficulty. They are saying from the bar. It is not on record. What was the actual?
So you mean to say the entire plot of land belonged to you?
Inherited by, because, my lord, because I was the, my lord.
So who will now come to this conclusion?
My lord, for that reason, my lord, they should inquire it before, my lord, filing this.
Okay.
My lord, kindly see the opposition. They have never said that it is not.
Sir, I'll fix it for orders because the read court will not go and measure the
Yes.
quantity of land. Heard the submission of learned advocates representing both the parties. Next date we fixed on 15th of September for orders.
Hello.
Next.
তোর মাল আর আমার মাল বেশি গেছে নাকি?
My lord, opposition copy reaffirmed.
Madam, you are representing which department?
Yes, yes.
You are representing which department?
As far as order, my lord, I am referring to this copy.
Yes, sir.
This is a case of
BSF,
CRPF.
CRPF.
There is on
Affidavit in opposition filed on behalf of the respondent CRPF be kept on record. Have you received the copy?
just given, my lord.
You will file affidavit in reply to
Kindly
this?
see whether earlier there is file or not the file. Kindly, for
Yes.
file.
আচ্ছা এটা reaffirmed copy করে দিন। This is the reaffirmed copy, madam.
Reaffirmed copy.
Next date be fixed on 23rd of September.
Well,
23rd of September for
23rd
hearing.
I appear for Respondents Union of India, my lord. On 1st of August, I have filed my opposition.
Prior direction was to file the affidavit of reply.
You have filed the reply?
Yes, Lordship.
You have filed the affidavit in reply? Ashun. Affidavit in reply filed by the learned advocate representing the petitioner be kept on record. You have received a copy?
Yes, just now I have received.
Proceedings are completed. The writ petition is ready for hearing. Next date be fixed on 24th of September.
For orders, Lordship.
For hearing, has it been?
Lordship has heard the matter in large.
Okay, I'll just finally hear it out once. Because you have filed the affidavit in reply today. Next.
35. 35.
I'm appearing for the petitioner, my lord.
My lord, pursuant to your lordship's direction, my lord, I have prepared the affidavit. My lord, by disclosing the amount of gratuity, my lord, my affidavit also says that the petitioner will be entitled to leave encashment. My lord, the interest part, my lord, what he has said, my lord, I am disputing on that, my lord. He is, according to my instruction, my lord, the petitioner will not be getting any kind of interest, your lordship. There are relevant circulars, my lord, which also shows that the petitioner will not be entitled to the interest.
My lord, I have submitted the circular, bank's own circular. Not only
Anyway,
in my
sir,
handout,
they
which I
have-
handed over to them,
they have,
but also in my supplementary affidavit also, I enclose my
Sir, the respondent bank has accepted your entitlement to leave encashment also. The interest part, it will be seen. Affidavit. No.
But my lord, interest is my statutory right because on the basis of their own circular.
Affidavit
May I
filed
refer
by,
this
in
circular?
the form of.
Because that is a huge amount. Huge amount. And I have not only given this circular, but
the form
also
of
several
report filed
judgment
on
of
behalf
this
of the
Honorable High
respondent
Court
bank be
and
kept
Supreme
on
Court.
record. Madam, have you served?
Right now, my lord, I have served.
That is the only point that gratuity and leave encashment they have not given. They have given only
Let the
pension.
matter be fixed on 22nd of September for orders.
Lordship.
My lord, may I submit about the interest portion?
Well, I can argue on that if a lordship.
Next.
It is already in the record, my lord, and this supplementary affidavit also includes the bank's own circular. I request your lordship to look into the Honorable Calcutta High Court 3 decision and Supreme Court decision.
Yes.
That interest is the statutory right and has to be paid for the lapse of the bank.
Next.
That is my submission.
Grateful to your lordship.
45, Lord, I appear for the petitioner.
20.
The grievance of the petitioner is that, my lord, the gradation list was prepared.
What is this different file has been tagged? There is another petition.
May I give the number, my lord? I was going to say that. The grievance of the petitioner is this. Grievance is that, my lord, the gradation list which is prepared, my lord, is not according to the rules, which says that as per merit.
But then on last occasion, this number was provided by you only.
So the number, the file is different, my lord. It's 21.
But then that was assigned by the Chief Justice.
Yes, my lord. The different file has got done. Different file has been given. It 21988. Some other file has been tagged.
89.
21988.
That
Is
is
the right?
That is the other writ petition filed by my learned friend, which is assigned to your lordship along with this matter. A different file has been tagged. This file should come.
21998.
No, 988 is the my lord assigned matter along with this matter. We have challenged the gradation list, saying that it should be as per merit in the entrance examination. A fact-finding committee was appointed by your lordship's court. The committee gave its report in my favor. it was recast. Now that recasting has
Okay,
been
let
challenged.
me, let us list it tomorrow
Tomorrow.
along with the main file. Then after you can submit because
Fine.
the department is directed to place the
That
case
was sent
record
to
of
that format.
WPA 21988 of 2024 along with the along with the records of the instant writ petition tomorrow.
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 Develop.
Tomorrow you submit.
Smile.
what-
Smile.
Madam, for the respondent bank, my lord.
এটার পরে না
Ramda computer bill. Ramda phone program vision computer bill.
who has filed this scan application? What is this scan application for?
Amendment of cost title, my lord. Now it is from Bongio Gramin Vikas to West Bengal Gramin Bank. It is amalgamated.
Gramin Bikash to
Bongio Gramin Vikas Bank is amalgamated to become a new entity. So it is West Bengal Gramin Bank.
so you are representing
I am representing.
the learned advocate representing the petitioner submitted to have filed a CAN application being CAN 1 of 2025, which inter alia stated in view of a notification being New Delhi, the 5th April, 2025, the Bongio Gramin Bikash Bank has amalgamated with
Three Gramin banks are merged and
Yes.
become a new entity. First paragraph. Now notification. No. Notification. No.
West Bengal Gramin Bank.
West Bengal Bank.
It was further submitted that in view of the aforesaid notification, all the other regional rural banks had been amalgamated into West Bengal Gramin Bank. Yes. Learned advocate representing the petitioner accordingly submitted that the first title of the writ petition be amended incorporating the name of West Bengal Gramin Bank in place of Bongio Gramin Bikash Bank. The department is directed to amend the name of the respondent bank from Bongio Gramin Bikash Bank to West Bengal Gramin Bikash Bank. So, CAN application 1 of 2025 is accordingly disposed of. Now the pleadings are completed.
Completed, my lord. Pleadings completed. Opposition, reply, everything.
Was there any hearing? No.
My lord, hard matter, twice matter. But opposition are concluded.
Oh, just tell me so that I can recollect what is the case. You said I have heard it twice. Only dates were fixed, sir, for your opposition and reply.
Yes.
Mm, mm.
There is a removal from service, my lord. My lord,
There was no constructive hearing.
Yes,
Only affidavit in opposition and
Ma'am.
reply were asked to be filed. That was there. Yes, he's not ready. Can't you find it out from his face?
Next date, my lord.
Next date we fixed on 23rd of September.
My lord. 23rd, 24 my lord. Now this is সবাই আছে তিনজনে আছে deeply obliged, my lord.
Yes, my lord, I'm for the petition. I'm sorry, my lord, I couldn't appear at the first call. My lord, this is a matter, my lord, in which, my lord, the petitioner was dismissed. A disciplinary proceeding was initiated. He was dismissed, challenging the
No,
proceeding.
sir,
Yes, my lord, I have
respondent
to.
one
I
three
intimated. Yes,
appeared,
they are the answering respondent.
but
and
they are saying that they are the private respondents and
my lord, incorrectly said. They are the answering respondent. They are appearing for the government company, Gluconet Health. They are the answering respondent.
they said, I mean, the learned advocate who was representing the respondent number 123, according to him, it would come under the Industrial Dispute Act. So this court is not the forum.
This point was taken by them, my lord, as an alternative remedy, my lord. This point was taken, but this is incorrect that they are appearing for the private respondent. Now, question is, my lord, this alternative remedy, my lord, can be an impediment, my lord, for taking up this writ petition or not. That point I have dealt with, my lord, and I have brought some judgments, my lord, dealing with that issue. Now, the thing is that, my lord, if your lordship fix any other date, my lord, except today and
No, I just wanted to know from you as to what was the problem in serving notice upon respondent number 4.
No, there is no problem, my lord. My lord, give me some time, my lord, 2-3 days time, I shall serve a notice.
Now, whether their presence is required.
No, their presence is not required. Respondent number 1, 2, 3, my lord, they are the answering respondent. My lord, my learned friend appeared on behalf of the respondent number 1,
Why
2,
did
3.
you implead them as a party? The
My lord, they are not necessary. They are proper party, my lord. They are the cooperative, my lord. I was working in a cooperative, my lord, under the company. So that is why he was made a party, and the inquiry officer was made. He was made a party, but today, my lord, as on date, my lord, they are not. My lord, their presence is not required. The company's presence is required. Company is the answering respondent, my lord. But I can serve a notice, my lord, since there was a direction. Let me serve a notice, my lord, and come back.
Serve a notice is secondary, sir. Primary is you have impleaded them as a party.
Yes, yes.
Now, sir, he was present.
Yes, I can intimate, my lord. Yesterday, I also intimated him that matter is appearing. I can once again, my lord, I shall intimate.
So when will you serve notice? You can do it within 2-3 days.
Yes, yes.
So that the initial issue at least can be resolved.
Yes.
Because he was challenging the maintainability at the
Yes.
forum.
Yes.
The learned advocate representing the petitioner submitted to have served notice. Where is your affidavit of service, sir?
No, my lord, it has not been done, my lord. That is why I was seeking time.
Notice upon the respondent number 1, 2, and 3. Full stop. The learned advocate, what is his name? Just
his name is Sujit Kumar Sharma.
The learned advocate appeared to represent respondent number 1, 2, and 3. Notice is to be served upon the respondent number 4 prior to the next date of hearing, and file an affidavit
Very
of
well.
service to that effect. Next date be fixed on 27th of August for filing of your affidavit of service, as well as on that point.
My lord, great.
I believe there are, considering the designation and the job profile
Yes.
of certain officers working under the Industrial Disputes Act, maybe from the managerial post, there is a clause therein where
This person, my lord, he is a Group C employee, my lord.
Group C, you find it out
Yes,
whether
yes, my lord, I shall. Great.
17.
কাকে একটা ডাকতে গেলে বললো
That I am appearing for the dispute.
I had given you passover, sir.
Well, my lord, Mr. Rai is there, my lord. He is engaged in court number 4, my lord. If your lordship kindly make it not to delay, my lord. He is engaged in court number 4. Hearing was concluded. I have submitted my short notes of written argument, my lord.
When, sir?
My lord.
When did you serve your written notes?
I have, sir, this for the first time matter is coming. Hearing was
That's why I'm
for
asking.
the first time it is appearing.
It is appearing for the first time. When did you serve? It was earlier dismissed. Then it was restored.
Thereafter it was restored, my lord.
So after restoration, it is appearing for the first time. When did you file the written notes?
Mr. Rai is engaged in court number
So I
4.
can see from the earlier order also on 6th of, though it was before the coordinate bench, on his ground accommodation was sought for.
Mother, I'm getting some problem in hearing, mother. Your lordship can make it not today, mother.
What is the matter, sir?
My lord.
What is the issue?
Issue, my lord, in this matter, my lord, on the basis of a preliminary inquiry report, I was reverted from the post of Senior Security Commissioner to the post of Assistant Security Commissioner. Now, my lord, I have challenged that order before this honorable court. This honorable court set aside the order and given liberty to the respondent to proceed with the regular inquiry proceeding. My lord, the charge
The
regular inquiry proceeding.
Hmm.
Now, my lord, the charge was framed on the basis of that preliminary inquiry report, but that was not supplied to me. I asked for the same, that you please supply me. They say that that is a confidential record. Oh, I will not supply. Now, my lord, when the matter came up for hearing, your lordship kindly come to the coordinate-based judgment. Justice Rajabasu Chaudhary passed the order that when you prepared my lord, frame the charge on the basis of preliminary inquiry report, so you are bound to supply him the copy of the same. You cannot withhold the same. First you say that it is a confidential record, I will not supply. Now they say that no, this confidential record, my lord, the report is not available.
But then they had to place the entire case record also.
My lord, the inquiry was conducted. He was given chance, but he didn't appear in the proceedings, my lord. Let you place the case. Notices were given.
No.
I am placing the case, my lord.
There was a direction of this court by the order dated 2nd of April 2024. The truncated records as produced by Mr. Datta is returned to him for him to produce the same along with the entirety of the records when the matter is taken up next.
This is the last order of Justice Rajabasu. This is
what is the date?
May I submit? This is the date of order is 2nd April 2020.
I'm reading out from that order itself. I've just read out from that order.
My lord. My lord, in spite of best efforts, the records could not be available. My lord, here are the correspondence. If you were to kindly consider, the report is not available in any way. It was searched throughout. If
So
the record is
without
not available,
which report?
Your lordship kindly adjourn for a week, my lord. No, my lord, I am opposing the same. Then you strongly opposing the same. Let me place the case. Not today, my lord. No, sir, I am placing the case. Because I am getting trouble. I am getting trouble hearing your lordship kindly consider.
Are you the advocate on record?
I am the senior advocate. Senior advocate, but the advocate on record is not there. Your lordship kindly make it not today.
Sir, your conduct as of the other orders that has been there on record. Today is the last chance, sir. You can't hear me, but you might as well hear this. Today is the last chance.
Before that, my lord,
Tomorrow
I have not paid any time, my lord. Only this time I am in.
Sir, will I read out the orders? Sir, will I read out the order sheets? It will not befit your submission, your age and everything.
My lord.
So better not on the learned advocate representing the petitioner is present on the prayer of learned advocate representing the respondent. Which department is it?
Hello?
Which department? Respondent?
Railway Protection Force.
RPF. Let the matter be adjourned for the day as last chance. Next. Tomorrow, sir.
Tomorrow.
Next.
I'm employing for the respondents.
Yes, sir. You had been engaged today?
Yes, well, the affidavit in opposition, that has to be seen whether they are on record. Well, I've been told that all have been completed.
Sir, on earlier occasion, one Mr. Niladri Saha had appeared.
Yes.
I don't know who he is. He said that affidavit in opposition and affidavit of in reply was to be served upon them. Sir, you had given it to him.
Okay.
No, no.
Yes, mine. I'll give it.
That was also given. Thereafter, nobody came.
Well, I will collect those, but only thing is whether they're on record or not. Whether the originals are on record, only that is to it.
So reply is in record. The opposition is not on record. So a copy was asked to be given to him so
My
that
lord.
he could reaffirm it and
Yes, ma'am.
file, which he has not done.
I will collect it, my lord.
And that is why the earlier order was passed. Petition and the reply is there, and they did not have the copy of the opposition, and that is why
Yes, ma'am.
copy of the opposition was directed to be given. So you collect it from whom?
I will collect it. I will collect.
The learned advocate representing the
The liberty may be granted to reaffirm, my lord.
What is it, sir? CISF?
Yes.
Yes.
Respondent, CISF. He used to file the reaffirmed copy of the affidavit in opposition prior to the next date of hearing. Next date we fixed on 15th of September. You will send it and then get it reaffirmed, or it can be done from here.
A little more time, my lord, little more. After vacation, keep it after vacation so that I can 100% I have it.
4th of November?
Yes, anytime.
4th of November.
Great.
Next.
We were supposed to file a report indicating the annuity calculation of pension in terms of the LIC scheme.
Yes.
But we have got that. But kindly, it has gone down as brief facts of the pension scheme. Kindly permits us to correct this and not number the paragraphs. It has come out in bullet points like which it's otherwise ready.
Show me. Have you given him a copy?
No, it is on the way, madam. I can hand over a copy to him.
To get the corrected copy, whatever Mr. Mujumdar will be filing PQ.
Where is the calculation, sir?
But calculation, it does not come like that. Not that it has been explained in the report.
Which one? Which paragraph?
Yes, it's on the basis of an annuity value per 1,000 rupees or per 1,000 rupees. So it was say 6.82. Now the higher the gratuity amount of an employee, this is non-statutory pension. The annuity value would come down like that. So one who gets 2 lakhs rupees as gratuity, might not be getting any amount of this non-statutory pension. Apropos a person who had got 1 lakh rupees as gratuity, but might be getting 600 rupees as pension. This has been explained in the report.
Now you are the company.
I am the company. I'm not the deponent of the writ petition. Himself was the president and signatory to the settlement.
And now you are saying the company neither has the financial resource,
It is not
nor
a
it can service any loan as budgetary support.
from the government.
Thus, in the event of union's proposal is required to be accepted, the entire funding would be required in the form of a one-time grant from the government of India. So you are saying you don't have fund
No,
to.
it's an annuity fund. The corpus is
Now, did you claim
constant.
the fund from the
No,
government?
the corpus is constant. There was a settlement. But if this settlement has to be upset in the event of the writ petition being allowed, but the president of the trade union, who is one of the signatories, who is the deponent to the writ petition, he signed the settlement. The pre-basic of 1983 would be reckoned for the purpose of calculating this pension. Now, the pre-basic of 1983 formed the basis of this annuity. So there is a corpus in the fund. From this, the eligible employees who were pre-83 employees and had received lesser amount of gratuity, they are getting some monthly pension, 500, 600, 800, according to the structurization of the scheme, annuity scheme maintained with LIC. If this has to be upset, then there has to be a fresh infusion in the fund, a huge infusion in the fund to cover all employees who are otherwise not entitled in terms of the scheme.
That is the stand taken by the management way back in 2011 itself, Lordship. And Lordship, that is at page 220 of the writ petition, Lordship.
The deponent of the writ petition was the president of the union, who was the signatory to the settlement.
Lordship will consider whether the settlements are in accordance with law, whether recovery of
Then why did you sign it?
Lordship, I will explain. Lordship, let them file that report, and Lordship kindly grants me liberty to file a short
You
exception.
were a party present in the time of the meeting.
And he's a signatory as the president, union president.
Me representing the writ petitioner association in this case. Lordship, nothing personal about it. Lordship, whether the action of the respondent number 2 in
But you represented everybody in personal capacity.
Lordship, the action of the respondent number.
Were you the representative? Yes or no?
Lordship, I will have to check, Lordship. Since Mr. Mojumdar is saying he is very senior, Lordship, I accept that my signature is there. I am not present.
It's on record.
That's why I did not dispute, my lord. That's why I did not dispute. But what I say, my lord, that the settlements are in accordance with law or not. Lordship, the payment of gratuity cannot be recovered.
No, we have not recovered
Is
gratuity.
being recovered. This is
Whatever gratuity, no. Unfinished transaction is probably incorrect on the basis of instruction given.
Lordship, let them say that gratuity is not being recovered.
It's already on record. Whatever is payable under the payment of, say, this gentleman, Mr. the President, he got 2,28,000 rupees as gratuity. Under the payment of gratuity act, there has been no deduction on that account. This is a non-statutory pension in terms of an LIC annuity scheme. So the condition is whoever gets higher amount of gratuity, he will get lesser amount of pension. And this annuity has a valuation factor like 6.28 for every 1,000 rupees. So 2,28,000, it has to be multiplied by 20.
This clause was included.
Yes, it was there.
In the settlement.
Yes. The settlement
said
said
had been a signatory.
The settlement said pre-1983 would be the basic pay reckoned for the purpose of this calculation.
Okay, so you rectified this and
My lord.
I mean,
Lordship, let it be not today. Let them, whatever correction they have to do, let them file it tomorrow.
What a paragraph number?
After such a long time, you have come up with.
I did it not in the manner it is required to be filed in the court of law, but not somehow. It's my failure that I did not personally supervise this.
The learned advocate representing the respondent. Number 2, sir. You are representing?
He is respondent number 2.
No, I'm respondent number 3.
No, 2.
2 is to file the rectified report by Friday.
My lord.
By 22nd of August. Let the matter be fixed on 22nd of August.
Wait for it.
You file the rectified report first then?
My
Next.
59, I'm
In this matter,
extremely
I am for the
sorry.
petitioner, my lordship. Mr. Pushpal Chakraborty is appearing virtually, my lordship.
My lord, I'm
Yes.
extremely sorry. I'm seeking leave of this honorable court to allow me to permit me to appear to virtual mode, my lord,
Yes.
physically. My lord, the issue in this writ petition is that I have challenged the entire disciplinary proceeding along with the orders passed by the disciplinary authority or order of dismissal passed by the disciplinary authority, the appellate authority, and the review authority. The primary ground of my challenge is that non-adherence to the rules formulated for the purpose of conducting the disciplinary proceedings. My lord, today, my lord, instance of such non-adherence to the rules will be evident from page 87 of the writ petition, wherein, my lord, if I may just indicate what is the contents of page 87 and page 80. My lord, page 87 is an order sheet dated 15/6/2017. In this order sheet, my lord, since an opportunity was granted to me to avail the defense assistant, my lord, I prayed for, it was allowed. I informed the authorities that my defense assistant will be available from a particular date. Accordingly, my lord, on consent of all the parties, this hearing was fixed on a particular date in the month of July 2017, my lord. My lord, now kindly take note of page 18. This is very important. Why I say so? This very inquiry authority, under the dictation of an 88, madam, 88, the very next page.
18.
Yes.
My lord, the disciplinary now, the inquiring authority, under the dictation of an outsider, my lord, what is the decide, pre-schedule the date, prepone the date by stating therein, my lord, if I may permitted to read the same. My lord, this is one dated 16/6/2017. Please refer to the last regular hearing held in the captioned inquiry on 15/6/2017, which was recorded in the order sheet dated 15/6/2017 and have been acknowledged by both the CSO, that is myself, and presiding officer and presenting officer for record and compliance. The competent authority monitoring the progress of the case has expressed serious concerns regarding negligible progress of the inquiry even after elapse of more than 4 months, which have been conveyed to the IA. Further, the IA has been advised to expedite the progress of inquiry. Accordingly, the undersigned, upon relooking the matter regarding the slot of progress of the inquiry, has reconsidered to hold the regular hearing by reissuing the earlier date fixed on 12/7/2017 at 12 p.m. to 16/6, that is on the same date at 4:30 p.m. in the above case to be held at the Chamber of Circumstances. My lord, nowhere in the rules I could trace out that such power has been granted to the inquiry, to the disciplinary authority, if at all this was the view of the disciplinary competent authority, the disciplinary authority, to dictate a disciplinary proceedings in which an inquiring authority has been appointed. This is the first, my lord, ground of challenge, that is acting under the dictation. Therefore, if the inquiry authority acts under the dictation of an higher authority, entire inquiry is conducted in a predisposed mindset. There will not be any fairness in the action of the inquiring authority. My lord, accordingly, my lord, the very next page, the proceedings, I have annexed all the order sheets. As a result of this, my lord, the proceedings commenced on regular basis. Accordingly, I was not being able to produce my defense assistant, although such liberty was granted. My lord, there was also no order wherein the order dated, which I first relied on at page 87, was recalled. Without recalling that order, my lord, this order was passed. My lord, so first, my first ground of challenge is biasness and unfairness in judicial action, my lord. My lord, after after that, the disciplinary proceedings started. My lord, there was no examination on my part. It was asked for, but since I had not the occasion to present the defense assistant, my lord, I could not examine. Thereafter, proceedings were conducted, and ultimately, I was held to be the charges against me. There were two articles of charges. One was of not giving due diligence in the grant of sanction of loan. The second was disproportionate deposit in the account in the accounts maintained by me and my family members to my salary. My lord, these charges were proved and I was held to be dismissed from service. My lord, now.
But sir, if you come to page 89,
My lord. My lord.
CSO has requested the IA that he wants to verify the documents in presence of his defense assistant only,
My lord.
and
My
the
lord.
regular inquiry hearing to start thereafter.
My
In
lord.
reply, the IA has stated that the CSO may accompany with his defense assistant, and in case his defense assistant does not turn up, the CSO has to complete the process of documents verification on the scheduled date of 19th of June 2017 without fail. The IA, after deliberation of the matter with the CSO and PO, has fixed the next date of hearing on 20th of June 2017 to be the chamber of such and such at 2:30 p.m. The IA advised the CSO to attend the proposed inquiry hearing with his defense assistant, and in case his defense assistant fails to attend the inquiry, the CSO will have to defend his case himself. The IA categorically directed the CSO and PO that the regular inquiry hearing henceforth would be conducted on day-to-day basis on and from 20th June 2017 till its completion, and no adjournment would be given. The CSO and the PO may note that no separate intimation would be sent to them in this regard, and if either of them remains absent, the inquiry will be held as ex parte.
My
Can't say, sir, that you were not granted any scope for hearing.
My lord, in this regard, my lord, may I just indicate page 87 once more? If I may, my lord. My lord, kindly take note of the paragraph, second last paragraph, which starts with the word therefore. My lord has got that?
Yes.
My lord, therefore, keeping in view, my lord, may I read?
Yes.
Keeping in view of the ensuing bank's quarterly closing for the quarter ending June 2017, and taking into consideration the request placed by the CSO, the IA directs the CSO and PO to complete the inspection verification of management documents on 11/7/2017 at Malda Town Branch. The IA consultation with the CSO and the PO has fixed the next date of hearing on 12/7/2017 to be held in the chamber of BGM such and such. The IA categorically directed that regular inquiry hearing would be conducted on day-to-day basis on and from till its completion without any injury. No separate intimation would be sent to the CSO and PO in this regard. My lord, this date was particularly fixed for the reason I pleaded or I submitted that my defense assistant will be available from a particular date. My lord will find that CO, just above the paragraph, CSO has stated that his DA would be available in the first week of July. Accordingly, my lord, my prayer was allowed and therefore this date was fixed. Now, my lord, in page 16/6/2017, my lord, this is a communication. But this communication does not reflect anywhere what are the circumventing circumstances, whether the order, which order number 4 dated 15/6/2017 has been recalled. If recalled, what are the exact reasons for the purpose of recall? My lord, there were also no indication as to who was the competent authority who has made such endeavor or who has expressed such serious concerns. My lord, good, bad, indifferently, ultimately this was a inquiry for imposition of the major penalty.
Now, in page 88, they are saying the competent authorities monitoring the progress of the case has expressed serious concerns regarding negligible progress of the inquiry even after lapse of 4 months, which have been conveyed to the IA. Further, the IA has been advised to expedite the process of the inquiry.
My lord. My lord, now, whether my lord.
Accordingly, the undersigned, upon relooking the matter regarding the sloth progress of the inquiry, has reconsidered to hold a regular hearing by rescheduling the earlier date fixed on such and such. So they have given an explanation.
My lord, now whether the rule permits an inquiring competent authority, if I consider this competent authority to be the disciplinary authority, to interfere into the disciplinary inquiry conducted by an inquiry authority, the inquiring authority. My lord, if my lord take notes, my lord, I am incapacitated today. My lord, this will be my first round of argument. My lord, can I continue tomorrow? I will be available. I want to do this matter physically. Can I come tomorrow, my lord? If my lord permits.
It won't be possible tomorrow. Come on 2nd of September.
My lord, my lord,
Lord.
my lord. I am extremely grateful, my lord.
Heard the submission of learned advocate representing the petitioner who appeared online. The learned advocate representing the respondent bank are present. On the prayer of learned advocate representing the petitioner, next date be fixed on 2nd of September for further hearing.
I am extremely grateful.
Next.
Yes.
Yeah.
Madam, for the petition. The time is needed to file my affidavit in reply.
Lordship, we have already served the affidavit in opposition. Just taking some time to.
Affidavit in opposition is on record.
I have already served. It's not on record. I am bringing the file. I have already served the affidavit in opposition. It's not on record before my lordship. Just bringing the affirmed copy. Yes. Affirmed copy.
Where is it?
Just. I have already served them.
Are you prepared with the affidavit in reply?
No, madam. The time is required, madam, to file my affidavit in reply.
When were you supposed to file the affidavit in
Lordship,
opposition?
we are supposed to file the affidavit on by 21st of July. Due to some departmental information, it got delayed by 7 days. We filed on 30th July.
Where is the copy?
Just a moment, Lordship. Just.
Sorry.
Sure.
You are representing the state. Affidavit in opposition filed on behalf of the state respondents be kept on record. Yes, madam. How long will you take to file the reply?
2 weeks.
The affidavit in reply to be filed by 8th of September. Next date we fix on 8th of September.
May it please your lordship's blood.
We have troubled your lordship, Lord, on previous occasions with a little bit of a problem on our side with regard to the change of the advocate. And in fact, on the previous occasion, Lord, it transpired that, Lord, the advocate who was then appearing had not filed the change, had not given the change in the Vakalatnama. Your lordship wanted to at least today see for your lordship, before your lordship, the new person who is taking charge. He has got the Vakalatnama signed and no objection has been received by him. If your lordship gives him leave to file it, Lord.
File, where is it?
Lord, it is with him, Lord.
এই আদিত্য দেখি ওয়াকালাতনামাটা কি আছে ওয়াকালাতনামাটা
সই করেছিস? This,
it's not a ready wakalatnama. That's
you will have to put the stamp.
I had asked this matter to come up at 2 p.m.
At 2 p.m.
Huh? 2 p.m. বলেছিলাম না?
Your lordship. কি স্ট্যাম্পটা রাখি বাকি আছে এটা?
অর্ডারটা কোথায়? লাস্ট ডেটের অর্ডার?
He was there, but he did not have the Vakalatnama of the previous advocate on record.
You file it and come at 2 p.m.
My lord, 2
File
p.m.
it and
My lord, at 2 p.m. My lord, I have some personal difficulty. My lord,
let him file the wakalatnama and then
if
come.
I can be represented through my colleague, my lord, Lord, because of this problem with regard to the Vakalatnama and the Lord, lack of communication,
Sir,
even
the
our
record
affidavit
will
reply could not be
itself
filed.
show the record will itself show the nature in which the petition has been conducted.
Your lordship is absolutely right. Absolutely
I mean,
right,
the
Lord.
hearing has been conducted.
Lordship is absolutely right.
So-
Lord, I was going through the order sheets. It's not a proper way in which matters should be conducted in the High Court. In fact, your lordship had to take the extreme step of requiring the attendance of the petitioner also on an earlier occasion.
Do you think there was any other way out?
No
sir?
other way out. Your lordship was absolutely right. This is a very wrong way in which Lord the
And moreover, the writ petition was dismissed earlier. It was also restored. You come at 2 p.m., let him file the wakalatnama in the department, and then he comes back.
Lord, whichever day your lordship fixes for arguments, Lord, I'll be happy. I'll assist your lordship, Lord. I was only begging your lordship for one thing. Because of this problem, our affidavit in reply also could not be affirmed because the advocate record had given change. New advocate record could not accept it. If I can give my
Sir,
learned friend a
on
copy
your
by Friday.
ground,
Yes, Lord.
they came and took a
Was being taken
yes, on
without
multiple occasions.
without any rhyme or reason. My name has been taken, and
I considered
your
that
lordship,
too,
and your
sir.
lordship was kind enough to accept it
Considered.
only because the name was
I
taken.
considered, but on the last occasion, I could gauge that something was
Yes.
wrong.
Lord, because your lordship did not allow, that is why they ultimately, Lord,
This would have been
this happened. Lord.
dragged for days and months and years the way it has been done. And then ultimately, sir, it is for the court to be blamed that no one functions and the matters gets piled up.
Absolutely right, Lord. Lordship is absolutely right. Lord, I've taken them to.
Sir, you ask him to
He
file
will be there. He will be
the
there, Lord, at 2 o'clock, and thereafter, Lord, if
wakalatnama by 2 p.m. Then I'll. Now, how long will they take to file the affidavit in reply?
Lord, I'll give a copy to my learned friend by Friday, Lord.
Then maybe 4th of September.
Any day, Lord, but suits your lordship. But I'll
Let's
assist.
first file it and
Fine.
then come.
I'm very
Lord, I will be represented through my colleague, my lord. My lord.
I'm very
একে ডিসমিস না করলে তো আসে না। আসুন। Where is Mr. Singh today? Then just see, you know that I generally don't dismiss. Kakoli Chatterjee. Just see if you can find her out. On the earlier occasion also, she was not present. And I'd like to pass over. Next. 82, my lord, I am appearing on behalf of the respondent insurance company. This is kindly, my lord. He's genuinely sorry. My lord understands. Maybe her choice of it's 163A, matter of 2010. Paper book is there. My lord, I'm there on behalf of the paper book is there. It's 163A, that's why, my lord, it can be disposed of. Any day, my lord desires. Claimants have already received 84,500 along with interest. The remaining balance they will receive. Ashok. The submission of learned advocates representing both the parties. Next date be fixed on 12th of November for orders. My lord. Grateful, my lord. 83, my lord. Thing is appearing on behalf of the appellant insurance company. I find from his brief that paper books were supposed to be given today. Who is for the other side? Mr. He was here. My lord will kindly pass it over. He was here just now. He spoke to me also. Next. You start your matter. Who is your other side? Singh is appearing on behalf of the respondent insurance company. She had to file the paper book has already filed. No, what happened? In a self-same accident in connection with another claim case, Mr. Singh was supposed to take instructions whether the award has been satisfied or not. Probably, my lord, let him come then. Probably he has then, not. 2 p.m. 2 p.m. My lord. My lord. My lord. 86. আচ্ছা এই যেখানে দেখি হ্যাঁ 85 তো 85
my lord.
আমি আছি তো কে আছে
86.
85 2 p.m. to file paper book. Claimants were directed to file.
85, my lord, I'm appearing my lord. I am filing paper book, my lord.
85.
85.
Mr. Singh is appearing on behalf of the appellant insurance company.
So let him come first.
Let him come, my lord, my lord, my lord.
2 p.m., my lord. My lord.
86, my lord, I beg to appear on behalf of the claimant respondents. This is insurance company's appeal. Lord, we have already filed our written notes of argument. And both the parties have filed our written notes of argument. That is on record, my lord. আমি দিয়েছি তো।
Why written notes?
Yes. At the desire of the court, my lord, both the parties have filed written notes of argument.
What is the issue that you need to file written
Just once.
There was a complete negligence. Negligence is there. Two vehicles collided together. Therefore,
Okay, Ashum. When did you file? Today or the earlier date?
On earlier date. On 17th June.
The learned advocate representing both the parties are present. Next date be fixed on 6th of November for orders.
6th of November for us. Much obliged.
And for the respondent insurance company, madam, I am ready with my written notes. Mr. Shubhankar Mandal and Mr. Ashik Mandal is appearing for the claimants, madam.
Ashum. None appear to represent the appellant claimants. Are you filing it?
If your lordship permits me, I'll file it.
You file it.
Well,
Written notes filed by the learned advocate representing the appellant, respondent insurance company be kept on record. Next date be fixed on 24th of November. 88.
59 Lordship, I appearing for the claimant appellant Lordship. Application for attainment of majority of the claimant appellant number 2. But we already filed Lordship. December 2005 Lordship.
You have filed CAN 2 of 2024.
Lordship. Yes, Lordship.
Ashun. The learned advocate representing the appellant claimant of India have filed an application in CAN 2 of 2024, which inter alia stated. Huh? Can you see? Now what? Is the records of CAN application being 2 of 2024 along with that of the main appeal. Where is it? CAN 2 has already been disposed of, madam.
No, Lordship. Last date to know. Order.
It's already been disposed of. Now, tell me, what is the issue?
So already paper book filed Lordship, kindly I fix for any date here. Copy already served.
Copy.
The learned advocates representing both the parties are present. On the prayer of learned advocate representing the appellant claimant, next date we fixed on 27th of November. Next.
Copy. And given I'm for that.
Yes.
Two grounds I have taken, that is, my lord, involvement of the vehicle. Second, my lord, the claimant failed to prove
Involvement of the vehicle.
involvement of the vehicle. Second point is, my lord, the claimant has failed to prove the rash and negligent driving of the driver of the insured vehicle, because there is no reliable eyewitness, and there is a contradictory statement as well deposed by the eyewitness as well as in the charge sheet, the version of the charge sheet. And third, my lord, rupees 88,000 was granted towards parental consultation extra. That is extra. Initially, a written complaint was lodged against an unknown vehicle. Page 38 is the
Parental consortium.
rupees 88,000 granted extra.
Yes.
Now, I kindly note my point. There is a delay of 8 days. And an accident took place on 22nd, 24 he died. Now, the
Delay of 8 days, you mean to say it has been explained?
8, my lord, in the FIR, the FIR maker is the wife of the this was a school teacher. Now, regarding the involvement, there is no question, because the eyewitness, the charge sheet, the serial list, everything, my lord, has been proved. There is no question of involvement, only thing delay in lodging FIR. This is my first point. My lord, this is covered by various versions of the honorable application and also our eyewitness. Second point, ration negligence. Not only eyewitness, charge sheet, and also other corroborating contemporary documents prove that there was a ration negligence. So second point answer is my point. Now third point, is 84,000 tribunal granted penal consultaria 44. Now recently, I have noted, there is at least 50 judgments. Supreme Court says, where there was a minor son, minor daughter, parental consultation should be granted. Immediate pronounce is not granted. Pronounce is granted only spouse granted. If your lordship desire, my lord, I can, my lord, give a list, recent, my lord, from May onwards, my lord. My lord, 40,000 for each and every case, my lord. The parental consideration, because they lost their father, they lost their mother. The sons will not get, my lord. Supreme Court specifically says, even my lord, kindly note my lord 3 points. Even my lord, the parental consideration, my lord, even if I consider 88,000, the matter may be disposed of, because there is no question of involvement of victim, because the my lord, the delay in logic.
Heard the submission of learned advocates representing the respective parties. Next date we fixed on 12th of November for orders.
I'm grateful to you.
Next.
Lordship, I am for the appellant, Lordship. Lordship, on the last occasion, your Lordship was pleased to direct me to serve upon the opposite parties, Lordship. I have served upon them by post.
I appear for the
Respondent number 1 to 4 and respondent number 5 says the server of India Post is down, so I could not able to make the affidavit of service, Lordship. Get the track report.
That is
Can-
Vakalatnama.
Yes, yes.
Lordship, there is
My Vokalatnama filed on.
Who will file the paper book?
Lordship, in this case,
He will file.
the stay petition was not moved, Lordship. Lordship, the can 2 is a continuation of delay petition, Lordship.
You will delay not be con.
39 days, Lordship. No,
Delay
Lordship.
not be con.
Lordship,
So you will
339.
go beyond the stamp reporter's report. The stamp reporter has
Kindly see, it is filed in 2024 and the delay petition filed in 2025
How?
with certified copy, Lordship.
How FFA number is
No, it is filed with a true copy.
বলছে delay আছে।
It is filed with the true copy, Lordship.
Then you come at 2 p.m. ওদেরকে ডেকে
Yes,
কথা
Lordship.
বলে নিন।
Next.
তাহলে
Because
ওরা
the trial
ওর সাথে
record was
বলছে delay আছে,
misplaced.
ওরা
It
কি
was
করে বলে delay নেই। ওদের ডেকে আনো। Next. ওটা 2 p.m. করে দিন।
My lord, I'm for the appellant in this matter. My lord, I'm seeking time to 4 weeks time to file my paper book, informal paper book, because the TCR copy has been transferred from the trial court to the this honorable court. So we the certain documents is missing from our records to file the paper book. So
On the prayer of learned advocate representing the appellant. Who are you? I never saw you earlier.
my lord, I'm from the appellant.
Which appellant?
New India.
I am leading, my junior is there, my lord. I am the advocate on record, my lord, for the appellant, my lord.
On the prayer of learned
I
advocate.
appear for the respondent, my lord.
Appellant Insurance Company, let the matter be fixed on 27th of November. The learned advocate representing the respondent claimants is present. Next. এটাও তো বোধহয় ওই মিস্টার সিং আছে তো 2 p.m.
Well, there is a last of
2 p.m. 2 p.m.
there to file an application for convocation.
Mr. Bonik, 2 p.m. 107 also 2 p.m.
2 p.m. 2 p.m.
My lord, in 109 I am for the insurance company and 10 is a court, my lord. This was fixed for orders, my lord, but it has come again, my lord. If it may be taken before the puja's vacation, my lord.
Ashun,
My lord,
Mr. Ashik Mondal is not there. Has he come
my lord,
today?
no, my lord, it will take some time to recover, my lord. Let, maybe it fixed after vacation, my lord.
My lord, last week of before closing, my lord. I will try my luck, my lord.
That I shall not
Submission
outstand.
of learned is representing both the parties. Next date be fixed on 14th of November.
Deeply obliged.
My lord, if last week I want to try this matter before your lordship's bench, my lord. Please, my lord.
Sir, most of your matters you're not there.
Lord, but I could not connect with your lordship, my lord. Your lordship saw me also on the screen, my
I
lord.
could see you. It was absolutely dark.
My lord, kindly give me one chance for this matter only. I don't pray for other matters, my lord, but for this matter.
For other matters you're not interested.
No, my lord, I'm well interested. For this matter, give me one chance, my lord. Before puja, my lord, let me try my luck, my lord.
What do you try? You try your luck elsewhere then if something otherwise. You can always try your
I'm for the respondent. My
Lord, intense stay was granted, my lord. My client has secured the entire address before this honorable court. Kindly stay to be made.
lord, regarding my lord, paperwork, my
আজকে
lord.
চঞ্চল আসি এসছিল তাহলে এটা একটা স্টেট অ্যাবসলিউট ওদের থেকে অর্ডারটা নিয়ে নেবেন ঠিক আছে Yes, who will file the paper book?
I shall file, my lord.
The learned advocate representing the respondent claimants intends to file the paper book and the same is allowed. You need the TCR to be
TCR,
called
my
for?
Yes, sir. I'm satisfied.
The learned register judicial service is to call for the TCR from the court of the concerned learned tribunal. Prior to the next date of hearing. Which district is it?
Alipur.
Alipur. Next date be fixed on 19th of September. for the-
19 September রাখলো হবে তো
Thereafter, you can prepare the paper book. Next.
same my lord.
Same?
Same.
Well, same order. Next.
Stay to be made. এটা কি TCR লাগবে নাকি
Have you given the copy of the challan
Yes, yes, my lord, just
in both the matters?
both the matters, my lord. Then same decision maker in this case TCR may
That I have said. Next.
15, I am appearing on behalf of Respondent Insurance Company.
Paper book already filed in earlier occasion.
Hmm.
This is the only question of quantum lordship. The learned tribunal declined to accept the evidence of PW1 on the question of monthly income of the deceased and accordingly come to a conclusion that the 5,000 and assess the compensation accordingly. Against the observation of the learned tribunal, I have come before your lordship.
What did the tribunal consider?
The tribunal consider lordship kindly come to page 44 of the judgment.
Hmm?
Page 44 of the paper book.
44.
Of the paper book. Just to kindly see he stated that the husband used to work as a tailor and cut piece seller at Durga Chowk and used to earn 8,000 per month, but except oral evidence.
When did the accident take
17.
place?
17, lordship. So lordship, the evidence and lordship, the observation of the there is no
5,000. You have come for enhancement of 5,000, right?
lordship. I have come
Only ground.
only ground.
Ashun. Heard the submission of learned. Can it be fixed for this? Heard the submission of learned advocates representing both the parties. Next date we fixed on 17th of November for orders.
Lordship, there is a only mistake as done by the learned tribunal in the page 48 that the national insurance company in the insurer, but lordship directed the United Insurance Company, but the national insurance company paid the same. But it's a wrong of the on that part. So that can be clarified at the time of hearing that can be.
Next.
Grateful, my lord.
Lordship, for orders, lordship.
For orders.
117.
My lord, issuing insurance appeal, in terms of your lordship's order, we have already deposited the entire amount before the Registrar General, and also there is the, my lord, affidavit of
Copy
service.
of the challan.
Challan. Challan আছে নাকি? আছে তো?
You have filed the affidavit of service also?
Yes, yes, my lord.
Ashun.
Paper book to file করে দাও।
Stay absolute. Affidavit of service filed by the learned advocate representing the appellant insurance company be kept on record.
There is another appeal filed on the side of the claimants. That is number is SMA 612 of 2025.
But is it there in the list?
It is not in the list, so you can
has to.
check with that.
The department is directed to tag the case record of the
এই নাম্বারটা বলো।
case records of the appeal being FMA 612 of 2024, along with the 2025 or 2025, along with the case record of the incident appeal on the next state of hearing. Next state we fixed on.
কই আরেকটা তো পেপার বুক একটা পেপারে কেন হবে কমন করে গেল ও কমন করেছো ও 612
Why have you filed?
Because on the point of quantum, Mr. Chakraborty is the file on the point of quantum.
Next date we fixed on 14th of November for orders. You have filed the paper book today?
I have filed the paper today.
Paper book filed by the learned advocate representing the respondent claimant be kept on record.
Both of you.
Today both appeal are not there. Today whichever appeal is there, it should be mentioned that only.
না 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 party
No, I'm for the appellant, ma'am. As per your lordship direction, my lord, I deposited the entire order amount.
Point.
Ashun, এটাতেও stay to be made absolute.
However, I shall file paper with
Sir, have you filed the affidavit of service?
or my learned friend appear.
He appeared earlier?
No. Previous occasion he appeared.
Previous occasion I appeared, yes.
But my lord, your lordship, my lord, desire asking me to file the paper. My lord, there at least 50 matters I prepare paper and file it. My lord, if your lordship desire, I can file paper, but the only point, my lord, in this case, my lord, my learning friend is driving license, and recover order. If your lordship feels for orders, I shall file the paper.
So this is conditional. If the matter is fixed for orders, then you will file paper book.
No.
Then?
A paper book, the materials are coming, on the
So you get the materials and then prepare the paper book. Next date we fixed on 18th of November for filing paper book. Next.
18th November.
পেপার বুক
Then all your matters prior to that, I'll defer.
My lord, she'll be, Mr. Singh is appearing, but she'll be giving the paper book.
Paper book.
Ashun.
Quantum point, very short point, quantum point.
Paper book filed by the learned advocate representing the appellant claimant be kept on record. None appear to represent the as a respondent insurance company. Next date be fixed on 19th of November.
My lord.
Next.
My lord, I am appearing for the appellant insurance company on the last occasion, my lord, on 7/8/2025. My lord have directed the stay of the order, stay of the impugned order, and 4 weeks was given, my lord. Maybe it has been wrongly included in today's list because according to my endorsement in my brief, it is 18/11 next date, but today it has appeared.
You have deposited the statutory amount, right?
My lord. My lord.
But you have not deposited the balance amount.
Yes, my lord. Only I have obtained the stay order on 7/8. My lord, today is 18/8. 4 weeks was given, my lord. It would have been, my lord, 18/11/2025. Next date was given, my lord. By mistake, maybe it has come as 18th August 2025.
Heard the submission of learned advocate representing the appellant insurance company. Order dated 7th of August 2025 inadvertently mentioned the next date to be fixed on 18th of August 2025. Next date we fixed on 11th of November.
My lord, I'm grateful.
Creation ব্যাপারগুলো কেউ আছে? তাহলে একটু কি আর তো 500 বার আর কিছু নেই তো?
My lord, to be mentioned matter, my lord, item number 5, only a very small mistake. Respondent number 1, my name will be there, and respondent number 2.
Yes,
my
it
lord,
has been noted.
Okay. I'm
Has-
grateful, my lord. I'm grateful.
আচ্ছা তাহলে তাহলে দুটো থেকে বসি।
My lord, I am appearing for the petitioner. My lord, last occasion, my lord was pleased to direct me to prepare a written notes of argument. I have made it. আর এখান থেকে inquiry report টা বার করো। I have handed over a copy. It's a bit bulky because I have annexed the judgments also and the DOPT rules also. That is why it became a bulky. And I am
Tell me in short, just for my recapitulation.
What has happened, the basic fact is that inquiry report টা এখান থেকে দাও। Basic fact is that, my lord, I was appointed as Assistant Administrative Officer with GIC, General Insurance Company, in 1979. Thereafter, I was promoted as Administrative Officer with NIC. I was allotted. The term is used is allotted because GIC is the parent company, holding company, and NIC was the subsidiary company. Thereafter, in 1990, I was promoted as Assistant Manager in the National Insurance Company. In 1985, an allegation was made against me that I have taken bribe of rupees 5,000 through a bearer check in order to process a claim in a progressive manner in favor of the particular party. On that basis, an inquiry was conducted. Inquiry 4 times inquiry date was given. First time it was fixed in New Delhi. Thereafter, it was fixed. First date was fixed on 16th April 1992 at New Delhi. Thereafter, the venue was changed at Calcutta. Next hearing date was given on 25th September 1993. On that date, I was on official tour. In their official tour, it was not a private tour. In their official tour, I was at Bombay. So I could not attend. The next date was given on 18 July 1994 and 19 July 1994. And for 15 days, I was in medical leave. The medical leave was sanctioned. On that day, when I was on medical leave, the inquiry was concluded. Inquiry report was submitted. And thereafter, the disciplinary authority asked me to furnish a report. I furnished a reply. I furnished a reply that was not gone into, and I was removed from service. My first allegation is that the person who has allegedly lodged the complaint of bribe, he has withdrawn the complaint. That was never exhibited. Neither he was ever called in as witness. Secondly, the bank through which the alleged check was cleared, the bank was never called as witness, because my lord will be aware that in cases of negotiable instrument, bank's evidence is sacrosanct. So that has to be done. Who has cleared that check? That has to be proved. In a writ petition, I cannot go into the minute details of appreciation and reappreciation evidence, but these are the basic facts which I must place address before your lordship. Now, if my lord kindly comes to one thing, my lord, I want to hand over. This is the inquiry report. The inquiry report which I have annexed is a bit illegible. So I have made a typed copy of this. Petition to the. In the inquiry report, if my lord kindly comes to internal page. ওইখানটা কোথায় inadvertent, there is no direct evidence যেটা inquiry report এখানে কোথায় আছে? Paragraph 12 of the inquiry report.
Something to do with the name. Signing of the name.
Yes, that is another point. They asked me to give a specimen signature in a particular name and style, not in which I used to sign. I used to sign as CV Kumar. They asked me to sign as C. Vardhan Kumar. That is what they issued me a letter, that you sign in a particular name and style. That is innocuous. That is absolutely, my lord, untenable, my lord. Because
why did you sign?
Well, I have a particular mode of signature. I cannot sign in a particular name and style what they demand me. I have to sign what I used to do. If my lord kindly comes to paragraph 12 of the inquiry report. That is at page 214. কোথায় এটা এটা মিলছে না তো।
As the documents marked exhibit S5.
As the documents at exhibit S5 and S6 are in the handwriting of CO, and as per the forensic science report, exhibit S7, the person who wrote those documents has also written the word CV Kumar on the reverse of the check. It is none other than CO who received the payment of 5,000 from the bank through the above check on 22/2/86. The tour bill dated 22/2/86 also shares that CO was present at Guntur on 22/2/86 during the banking hours. Through there is no direct evidence to substantiate the allegation. This is what I am wanting to realize. That CO made a specific demand for getting the claim settled expeditiously in view of the fact that amount of rupees 5,000 was withdrawn by CO from the bank through a bearer check, and the company also received the claim money after a few days of the encashment of the check. There is strong possibility that CO made a specific demand to the company to pay rupees 5,000 for getting the claim settled in a day or two. So there was no direct evidence. Neither the bank was called, neither the complainant was called. Everything was done on circumstantial evidence. They themselves are admitting that. Now, if my lord kindly comes to, I have to make an lengthy submission regarding this writ petition. It's a voluminous one. If my lord kindly comes to page 216, my reply to the inquiry report of the writ petition.
আছে? এটা তো petition, what's a reply to the
Applicant na petitioner. দুশো ষোলো 216 216 হ্যাঁ This is my reply to the inquiry report. Kindly come to paragraph 1. The alleged bribe was demanded on 19/2/86 by the CO from Nadella Lakshminarayan, and the said check was encashed as per charge sheet on 22/2/86, and then some 5 years 9 months after that the memo of charge sheet was issued. There was unusual delay and latches on the part of the management. Further, from the letter dated 17/5/87 of the firm Nadella Venkateshwar Rao and Company addressed to the Vigilance Officer, National Insurance Company, it appears that the partner of the firm Nadella Lakshminarayan reported about the bribery on 17/5/87 on the asking of the Vigilance Officer. This further proves 3 matters. I am directly coming to 3. Next page. It cannot be the case of the AGM and CA that investigation prior to charge sheet was done with reasonable dispatch leading to memo of charge sheet. The alleged bribery took place on or about 19/2/86. Such letter from the de facto complainant Nadella Lakshminarayan was obtained by vigilance officer on 17/5/87, and the memo of charge sheet was issued on 2/12/1991. The memo of charge sheet does not mention the name of Nadella Lakshminarayan as a witness, though the entire proceeding started from his action as alleged. He was not examined as a PW. The only presumption is that had Sri Nadella Lakshminarayan been cited and examined as a PW, his evidence would have been negated the prosecution story. The delay and latches shown above also make the charge sheet liable to be quashed in view of the decision of the Honorable Supreme Court. In Bani Singh matter, I have annexed with the written notes. Now, I will kindly come to the next paragraph, point 1. All the 5 management witnesses were examined on 18/7/1994 when CO was absent on medical grounds, and his earned leave was sanctioned by the competent authority by letter dated 11/8/1994 for 19 days from 18/7/94 to 5/8/94, copy annexed. Ex parte hearing against the CO when he was on genuine leave is bad in law, and the inquiry report emanating from such ex parte hearing or inquiry is also bad in law. The CDI and IO ought to have given opportunity to the CO to cross-examine the PWs even by adjourning the date of inquiry. The first date of inquiry, what I have stated, There different dates were there. On next date, it was I was
So
on.
you had not been given the opportunity to
Yes.
cross-examine.
In their affidavit in opposition, they themselves say that notice could not be served on the charged official. It is a statement on oath that notice could not be served on the charged official on 25/9/1993. In spite of that, date was fixed on 18/7/1994 when before that medical leave was granted to me. I was hospitalized. I obtained, I made a representation from the hospital itself.
So this is the only ground or anything else?
There are several grounds. The de facto complainant was never examined. In fact, the letter of complaint of the de facto complainant was later subsequently withdrawn by the de facto complainant, which was never exhibited. That is at page 107, if my lord kindly comes to that. 107 of
Why
the.
is it withdrawn?
I'm telling, my lord. Before charge sheet. 25/9/1987. Charge sheet was given in 1991. I submit that I hereby withdraw my statement given to you that our check number such and such dated 2286 drawn on Central Bank of India, Guntur was collected or drawn by Mr. C. Vardhan Kumar, branch manager, such and such. This was never exhibited. Neither the bank was exhibited, marked as a, neither the bank was called as a witness. Bank never came to depose. And amongst the witnesses, prosecution witnesses, one never came up and another one became hostile witness. What a page number to bolo to.
The complainant was examined.
Complainant was not examined. Complainant was not examined. That is my point. That he has issued a withdrawn letter much before the charge sheet, but that was not exhibited. Neither the de facto complainant was exhibited, deposed, witnessed.
Okay.
At page 106, there are 7 witnesses, out of which PW3 is the person who processed the alleged claim. I was not authorized to process the alleged claim. He was my superior. He was empowered to process the.
Yes, sir, I have now recollected.
But he did not come to depose, and PW5 became hostile witness.
So you have to submit or you have completed?
No, my learned friend has just completed.
And another point, just 1 minute, sir. Another point is that the removal order, which they are purportedly stating as dismissal order, that was never served upon me. What they have stated in their affidavit upon oath, I do not know how can this affidavit opposition to the, how can this affidavit subsist in the eye of law? There are 2 affidavits. Affidavit দুটো আছে.
You have mentioned that in your notes, right?
I have mentioned that, but I want to place one thing that they say I was in the office on that day, 22nd February. আরেকটা আছে 18ই মার্চ 1999. They say that I was in the office 22nd February 99, that removal order was passed. On 24th February, I was in the office and they attempted to serve upon me. I refused that. That is what they say, because removal order has to be served upon me. That is mandatory under the rules. But what if my lord kindly comes to the affidavit in reply, my affidavit in reply, the attendance sheet I have annexed, wherefrom it will appear that I was absent on that day.
Which page?
Affidavit in reply, page 57, 58. Affidavit in reply. C.V. Kumar, assistant manager, I was absent. 24/2/99. And they are upon oath saying that it was attempted to be served on me. Upon oath, this has been done. This is perjury. This is serious offense.
Okay. On the next date, I will hear him. Then you again come.
Right. And I shall place some rules also.
Written notes filed by the learned advocate representing the petitioner be kept on record. Heard the submission of
Yeah,
learned
okay,
advocates representing the respective parties. Next date we fixed on 4th of September.
Instead of book of any other day, because I may not be.
12th of September.
I'm grateful.
Number 2.
I am for the respondent.
Your Lordship, item number I'm paying for the note today, Your Lordship. The learned advocate on record appearing this matter is not well. Lordship has not come today.
Acha.
The substitution application file order.
এটা কে নিয়েছে?
Lordship, last occasion.
Wait, sir. এটা কাজ করুন।
हमको सर नहीं किया।
The advocate on record?
Your Lordship, I'm not the advocate on record. Your Lordship,
Then who are you, sir?
Your Lordship, I'm appearing for the advocate on record. He is not.
You are appearing for the advocate on record.
He is not well. He has not come to the court,
Yeah.
Your Lordship. That's why.
The none appeared to represent the petitioner. The order dated 25th of July 2025 has not yet been complied with. The learned advocate representing the sir, you are for the ECL? Respondent ECL is present. Let the matter be dismissed for non-prosecution.
Your Lordship, kindly not. Your Lordship, kindly consider this. Kindly keep it on next Monday, Your Lordship.
নামটা দিয়েছি নামটা দিয়েছি দেওয়া আছে নামটা দিয়েছি এটা করো প্রীতি ব্যানার্জি
আগে ওই পাঠাতগুলো ডেকে দিক তারপর হ্যাঁ রিট টুকু সেটা একটা ডাকুন।
beg to appear on behalf of the petitioner. My lord, in this matter, a report was submitted.
66, I'm for the respondents. Yeah, must be checked out.
My lord, a report was submitted and today was fixed for inspection of the report, my lord. My lord, it's in a sealed envelope with your lordship's permission, we had sought for inspection of the report, whatever has been submitted, which is against us. And on the basis of that report, we are willing to file a supplementary affidavit, my lord.
My lord, it's a confidential report. I leave it to your lordship, but how far they are entitled to inspect the entire record, it's a question of law, my lord.
My lord, that has already been argued on the last occasion. I was led by
I can make further arguments.
Mr. Shoptanshu Basu.
Mr. Basu's contention was the recommendation of the commandant was not tallying with the recommendation, with the final recommendation of the DIG. That's why my lord called for the records to see that part only, not the entire records. They are not entitled. I leave it to your lordship, but at least, my lord, many confidential noting are there.
On the basis of that, the trial has been.
Mr. Basu alleged only that part. Mr. Basu also showed a judgment that Ramakrishna Pathak versus Union of India.
Where is Mr. Basu?
My lord, presently he is in Jalpaiguri Circuit Bench, my lord. My lord, on the last occasion, as it was fixed for inspection, my lord, he has instructed me to inspect the records, whether it is matching with the records that we are already
Where is
having.
the order of inspection?
My lord, it is fixed at 2 p.m. for inspection. Maybe it is not reflecting in the order.
No, it's not.
It is not reflecting in the order, my lord. And it has come before your lordship, and your lordship had heard Mr. Basu and had allowed the inspection of the records, my lord.
What is the problem is that he is going to retire in March. Now, if this writ petition already of 2021, now 4 years have passed, he is enjoying a stay. If this continues to go on, then we will have no recourse.
Next year, March.
Next year, March. Obviously, any of the parties who are aggrieved will prefer an appeal and it will go upwards.
Have you completed with the?
Yes, but we could not publish the final award because there is an embargo of this honorable court.
My lord, the trial has not been convened in following all the procedures, my lord. That is the challenge in this writ petition.
When he will be here?
My lord, he will be here tomorrow.
He'll be here tomorrow. So I'll fix it up tomorrow, and in the presence of both of you, this court will go through the portion which he pointed out.
Yes.
Right?
My lord may remember that Ramakrishna Pathak's judgment was
They are
cited.
taking a chance.
Yes.
Grateful, your lordship. Have you? Take.
The learned advocate representing the petitioner submitted that senior advocate, Mr. Shoptanshu Basu, is presently in circuit bench at Jalpaiguri and will be appearing before this court tomorrow. Let the matter be fixed tomorrow at 2 p.m. Let him come tomorrow.
I'm obliged.
I'm grateful.
For the appellant led by Mr. Kollal Kumar Basu, he is on the way, my lord. He is coming in this court, my lord. Only 5 minutes pass over.
It a paper book, no?
But
Your lordship had heard it at length.
Now, according to you, there was no TI parade held.
No. And my lord, full
And the
contradiction.
trial started after 14 years. This is what you said.
Yes. My lord, a small note of argument I have prepared for that time.
And according to the state, since the appellant was caught red-handed, TI parade was not
But
required.
independent witnesses, my lord,
Okay.
should not state that.
The learned advocate representing the appellant. Appellants are present. None appear to represent the state. Written notes filed by the learned advocate representing the appellant be kept on record. Hearing concluded. Sealy.
Hot notes on submission.
I've mentioned. Next.
Is it sealed? Okay.
Acceptable. People. None appear to represent either of the parties. Let the matter be adjourned for the day as last chance. Next.
There are arguments in this. So far as I was concerned, this was a matter. Lordship would remember that we were preparing dikes.
Yes.
On 4 occasions, they've taken time. I hope they finish it today.
Well, we'll finish it today.
Well, if they finish it, then I'll just reply to whatever they have. But does your lordship want a recap? A recapitulation of what was right. Knowing your lordships, I thought as much. That's why, knowing your lordships, I thought as much. That's why I didn't argue further. I don't have to recap. Great, my lord.
My lord, the matter in gist is that, my lord, the petitioner company was awarded a work contract from the irrigation department, which was later on they have handed over through subcontractors to the de facto complainant, my lord. The work was in process. During the work, they came up with a memorandum of understanding and an NOC stating that there is a pre-existing memorandum and with some other company, namely Memcon, and they ostrated me from the work contract. There is a huge amount is still pending from their end, my lord. Now their statement is that, my lord, sometimes they have the person for the Memcon, they appeared to them and they produce this memorandum of understanding and NOC to them stating that he has been appointed as a subcontractor or partnership partner, whatever it may be, as a subcontractor to the agreement. And on the basis of that foreign document, which was basically produced by a third party, petitioner company disbursed my amount to the third party without taking any consent from my end, without taking any authorization, without verifying the document. They simply handed over my amount to them, ostrating me from the work contract. Now, my lord, if your lordship petition petition if your lordship kindly takes up the NOC ones, that is at page number page number 79, annexure P10. Of their petition, my lord.
Yes.
Now, admittedly, this document was produced by the third party to the petitioner company, and on the basis of this document itself, they have disbursed all the amount to that third party. Now, my lord, kindly come to the last paragraph once of that NOC. This is the purported declaration by the de facto complainant or the person authorized by him. I also undertake that all the liabilities prior to 1908-2008 will be the entire responsibility of Technician Guild, and GWRL will not be held responsible for any dispute whatsoever against above subject order once the above arrangement comes into effect. So this is theirs, as per their version, as per this document, the de facto complainant herself has admitted that whatever responsibility was there prior to 1908-2008, all the responsibility belongs to me. Whereas, my lord, in the earlier documents, it has been admitted by them only that there is an outstanding due of 7 lakhs rupees as per their claim, and as per our claim, there was an outstanding due of 25 lakhs rupees. So obviously, this is obvious. When for the sake of argument, let us consider that if this document is at all a genuine, then also only a fool can take the responsibility without getting payment of his due amount, and can take responsibility of the entire work accomplished by him prior to 1908-2008. So basically, this document is manufactured and it is cleared from these facts only, because obviously no rational person cannot take this responsibility without getting his payment. My lord,
there was a memorandum of understanding.
My lord,
they had introduced the third party on their behalf.
My lord, this is kindly come to paragraph number 6 once, my lord, of their petition. My lord, pardon, my lord, page number 3 of their written notes of argument. That is written in the petition as well, but I have pointed out in the written notes of argument. Page number 3 of their written notes of argument, paragraph number 6. Just now they have stated that this memcom was introduced by the de facto complainant. Now let us consider their statement in the petitioner. Subsequently, Mr. Shopon Mojumdar, on behalf of Memcom Enterprise, who used to be present in the business discussion, site visits, along with opposite party number 2, complainant, and supervise the work in presence or absence of opposite party number 2, complainant, and was introduced and made known as partner of the opposite party number 2, complainant, approached the said GWRL and represented to complete the work order number such and such dated 4th June 2007. He placed before the said GWRL NOC no objection certificate dated 18th August 2008 issued by the opposite party number 2, complainant. So basically, the NOC was produced by that third party MEMCON, not by the de facto complainant. So their statement of introducing MEMCON by me, this has been corrected by their statement only, which has been affirmed in their petition, my lord. Now, my lord, regarding their submissions and the points of
party number 2,
that is,
see that,
yes, my lord, opposite party number 2,
opposite party number 2, complainant,
my lord,
and was introduced and made known as partner. Who did it?
My lord, this is a subject to be challenged, because I am telling you, my lord, because these facts can only be proved if there is an independent inquiry in this matter. Who proved this? Because there is no documents in between. There is no correspondence from our end, no correspondence from their end, accepting MEMCON, or neither I have ever introduced.
Tripartite.
There is an agreement, well, P6.
There
But we
was
have only put their
tripartite,
side.
My lord, we have challenged that agreement as well, my lord.
Part of the annexure.
We have part of the annexure. There is no scope for discovery of a new document in the revisional jurisdictions.
They have not challenged. I don't see that challenge in their opposition anywhere. They are relying on you.
Now, my lord, let us come to their points of challenge, the for quashing. So far as my concern, my lord, point number 7 is the main point which, if can be dealt with, then all other points are already covered up. Point number 7.
Responsibility,
my lord,
which you had to discharge,
my lord,
had been discharged by the subcontractor.
No, my lord.
No.
No. I have discharged my liability with 10% above work. The contract was given for completion of 120 geotubes. I have completed 130 geotubes. And against that completion of work, they have already get disbursal of amount which was actually given by the irrigation department. So they have received the amount from the irrigation department, and in order to defraud me, they have created a third party, namely MEMCON, in between, so that I can be deprived of my rupees, which is not less than 1 crore 50 lakhs, and by paying a meager amount.
So you mean to say MEMCON was unilaterally introduced by them, by the petitioner?
My lord.
Without your knowledge?
My lord.
Just to
deprive me
of your
legitimate
claim.
My lord.
That is your case.
My lord.
So you are no way connected with MEMCON?
No, my lord. And that is the point where the investigation or inquiry is necessary. Now let us consider their point. That is why I'm stressing on the inquiry part, my lord, because their point, let us consider their point first, my lord. Point number 7 of their written notes of argument, non-compliance of section 202 of the Code of Criminal Procedure. Now, before placing their arguments, my lord, let us consider the section 202 once, my lord. Section 202. May I place, my lord?
Yes.
Section 202 CRPC. Postponement of.
In what context are you mentioning section 202?
Because section 202 says that for any, I'm just pressing relevant portion, then I'm stating, my lord. Any magistrate on receipt of a complaint of an offense of which
your address is beyond the jurisdiction.
Regarding that, they have stated that the petitioner, he is residing outside the jurisdiction. He is a resident of Mumbai. So basically, there is no compliance of section 202. So if there is no compliance of section,
we will see later on. You come to the relevant point.
My lord, this is the main point. If this is being considered, then all the points will be covered up, my lord. That is why I'm first placing this point only, because only the quashing can be done only on the basis of this point, whether there is a compliance of section 202 or not.
For the sake of argument, let us say there hasn't been any compliance.
My lord.
Beyond that, you'd have to say anything?
No, my lord. I'll just move on to their points only, my lord.
No, forget about 202 for the moment.
My lord.
Right.
Regarding facts, we have nothing else to say, my lord, because we are praying for an inquiry in the matter. Similarly, what they are praying, that an inquiry should be done in the matter, so that this.
They have come for quashing.
My lord, but
they are not seeking any inquiry.
That is why, my lord, section 202 says that compliance is necessary. Compliance for section 202 is necessary. Now, admittedly, there is no compliance from the learned magistrate below on this point, that petitioner was not, this inquiry was not done. Now, my lord, the consideration should be
Let us let us try and find out prima facie
My lord.
your role.
My role, my lord.
Yes.
My role in the entire proceedings, my lord. Obviously, my lord, I have completed my job.
You had been absolutely oblivious of whatever has taken place with regard to the petitioner as well as the subcontractor.
My
right?
lord.
So you were not a party to any memorandum of understanding.
Absolutely not, my lord.
You were not any. You were not the person to have introduced the subcontractor
My lord.
to the petitioner.
My lord. And NOC was not given by me or under my instructions, and that is admitted fact from their petition only. That I have already shown, my lord.
Anything else?
With regard to facts, I have nothing else to say, my lord, because the fact is only this much. Now, regarding quashing, whether 20.
Now, sir, you had completed a substantial amount of the work.
My lord.
So, correspondingly, what was the amount that you had received?
That is already in their petition, my lord.
So the entire work was allotted to you through one transaction, or there was different?
My lord, actually, there are four contracts. There are 4 work contracts. At a time, 4 work contracts was going on. 2 was in Sankarpur, and 1 was in Shagor, and 2 was in Shagor. So at a time, 4 work contracts was going on between the
Against 4 work contracts,
my lord.
You had received certain amount of payment?
Definitely, my lord. I have
You had
received. I have received. That is, they have annexed as well, my lord.
And the balance amount, according to you, were not paid to you, but to the subcontractor.
My lord, by fraudulently introducing a foreign document, by using my document in their favor.
Your document?
My document means, my lord, this document was not known to me at all.
Which document?
This memorandum of understanding and the NOC. That is at page number 66, my lord.
Yes.
Now, my lord, if your lordship kindly come to that page, at the last of that column, 31st August 2009, payment made to Memcon Enterprise on behalf of Technician Guild to complete the balance work at Shankarpur project. This amount was paid 12,70,000 rupees.
So from 2002 from 12th May 2007 till 31st of August 2009, you had been paid?
On the basis of my completion of every work, I raised invoice. Accordingly, they made payment.
How much did they pay you? How much did they pay you?
31,29,948.
From where did you get that?
That is, my lord, deducting that amount, my lord. Page number 66, my lord.
Yes, it comes to 1,79,26,577. Credit is 1,35,26,629.
Regarding the exact amount of the payment, I have to take instruction once because I'm not available.
You don't know how much you have received?
Exactly what amount I have received, that I don't know. But on the basis of my invoice, I have been paid.
Show me that tripartite agreement once.
P4, my lord. 56.
56.
56 is between my lord Technicians Guild, which is my learned friend's client, and Memcom, who is the subcontractor. Neither has this agreement been challenged anywhere.
56, that's P4, right?
My lord. Not the arbitration being invoked.
You are the technician guild.
Well, I am Garware.
No.
I had given the tender. Well, this is between Technicians Guild, who is the contractor, along with the subcontractor, who is Memcom, which is Memcom, my lord. বলছে এটা কন্ট্রাক্টটাই নাকি হয়নি।
হ্যাঁ, our whole case was on this. There's arbitration rules.
হ্যাঁ, ঠিক আছে। my lord দেখতে চেয়েছেন এটাই।
Oh, huh. And
No,
look at the
if I'm
date.
not wrong,
Yes.
you had shown me one document between these two.
This is the document.
These two.
This is the document. Between these two, this is the document. And I would insist your lordship would kindly see the date of this document. The date to kothay gelo? 5th June. This is Memcon and Technicians Guild. This is the document, my lord. Your lordship is absolutely right. This was the document. And kindly comes
Now
to
they are denying this document.
Kindly comes to page 57. Kindly sees whereas the scope of work which is there. This was the coastal project. This is the one that we were doing. Now kindly comes to page 58, paragraph number 6. Page 58, paragraph number 6.
Now they are this had seen.
Now kindly come
Now
to
page 61 also
Yes,
I've
yes,
marked.
yes,
Page
yes.
paragraph
Paragraph
number
60.
16 and 17.
Absolutely.
There was an arbitration clause
Yes.
also.
And now once they've not got the document, the easiest way to say is that we deny this document. And my lord sees the reply. Key. What about reply? Where?
Now, first of all, you come to page 66 once.
Yes, my lord.
Now, I had asked them as to how much they have already received. They could not say the exact amount.
Your lordship wants us to indicate what was the...
No, I had asked them to say as to the amount they have already received.
Yes.
Now, you go through the chart.
Yes, my lord.
1,26,577.
Yes.
Thereafter, 1,35,26,629.
Balance is
this. Are they claiming this? I mean, what is the amount to have been defrauded? That is what they are saying. Yes.
Well, gives me 1 minute, my lord. Just give me 1 minute. This is technician.
If your lordship kindly allow me,
Just a minute.
can I confront from the?
You should have done it earlier, sir.
I
This is
just
not
give
the
one
place to
clarification.
hold conference with your client.
This is so far that they do, and we've paid.
This is stage till their work was completed.
This is Technicians Guild, and we've paid Technicians Guild.
Yeah.
We've paid Technicians Guild.
So much.
We've paid Technicians Guild to this amount.
Debit agent.
But Technicians Guild have been paid 1,79 lakhs. This is what they've been paid, and credit is this is what is, but the balance is this is what was remaining. This is what was remaining.
Now, this technician guild, they have not been made party.
They've been made a party by them as an accused. Whether they came up or not, we are not aware.
So, in the complaint, they are also a party.
Yeah, they are also a party.
You have come up for quashing as far as you are concerned.
Yes, because we paid the money. And I was the managing director.
Now, they are denying the agreement.
Yes.
which they had signed with technician guild.
And then they don't do the work. If your lordship wishes to see how they've placed themselves in the affidavit in opposition, your lordship would understand. I'd in fact placed it before your lordship. They say that they were working. They say that they stopped work. Then they started saying, they also don't deny fully that technicians guild was not there. They say that this document was not there, whereby we've effected payment. Now the issue is that they did not work. Finally, they did not work. A. And B is that I am not the beneficiary of this document. I am not the beneficiary of this.
So whatever their grievances are
with technicians guild.
with technician,
and we are covered by.
Now they are denying that no objection certificate.
Yes.
Stating that it was not issued by us.
That is a different document. They are not denying this agreement.
No, they are denying the no objection certificate also.
No objection certificate is different. Agreement is different, my lord.
They are denying both. You are not there.
Okay, they are denying both, right?
They are denying both. Today they denied both.
My lord, on the basis of the no objection certificate, they have disbursed the amount.
That is what his contentions are.
In their opposition, they have
That they have not issued that NOC. Neither did they sign that agreement.
This is their document in their reply. Annexure 17. They say they have signed.
But it comes to page 17
of their.
They say that they've signed. Page 17 of their reply. This I'll tell you a lot of the document. They do not. It's a very tricky situation. My lord, the document is affidavit and reply on behalf of the opposite party number 2 against the supplementary affidavit on behalf of the petitioner. In this document, it's affirmed in September 2023.
When?
Your lordship has got the document.
So many. 27th of September.
My lord, that date is empty so far as we are concerned. It's September 2023.
23, yes. Tell me.
My lord, kindly comes to page 17. This is the GD entry which was lodged. This is the paper that we weren't getting, ultimately because of intervention of this honorable court that we finally got. My lord, kindly comes to this document. I would like to inform you, this is being issued by them, that the above named Shopon Mojumdar is originally the partner of Memcon, but before various authorities, he is representing himself as a proprietor. And I have been long business relation with him and one of his friend, Kishore Chatterjee, who used to make legal drafts for us. As we have good business relation and friendship, I used to prepare drafts and final documents from them. I said Shopon Mojumdar took that opportunity as I called Kishore Chatterjee to prepare an agreement between my company and Garware Wallropes. And having good faith upon them, I also put my signature on 100 rupee, my lord, can you note this? 100 rupee, a non-judicial stamp paper and one demi paper. But subsequently, on or about 20th September 2008, when I tried to communicate with the said Garware Wallrope, the said company informed me that I have no agreement with them and also issued no objection for agreement between Memcon and Garware. So he actually admits to have put the signature and says that I did not know the contents. And this is the volte-face with regards to the complaint which is being filed. They are changing stance. Now, I am really not bothered as to what their stand is because we are not the, again I say legally, we are not the beneficiary of the document. We are completely covered by Sheila Sebastian. They are the persons. Who am I? I am not a person from Bengal. My company, and worst is the company has also not been made a party, my lord. That's another legal proposition which by itself is good enough for me to get exonerated. But the point is that as the managing director, I'm being called in for what? For me starting a coastal project upon getting a tender. I use somebody, a subcontractor, that subcontractor gets subcontractor stops performing, subcontractor comes up, says that yes, I will perform, produces a no objection certificate, I pay half to subcontractor, half to subcontractor. He takes the money, now he says, why have you paid? And they come up with this agreement that it's going to be on the sees that agreement one more time, where they of 2007. One sec. Baba, 56. Page, oh, right, yes, sorry. Page 56, my lord, kindly sees. Your lordship was already seen. Page 61, your lordship has seen.
Yes,
Now, page,
but that is between them.
yes. And this is what was produced to us to show that they're a party to the whole thing. Otherwise, why would we take? My lord, if we, just for a minute, if we see logically, if we had to oust Memcon,
Now, you have not issued any kind of documents or communication to them that based on your understanding through this agreement between them, you had delegated the work.
they stopped coming only. That was our case. They came up later. But subsequently, on or about 20th September 2008, I tried communicating with so and so. So, my lord, kindly sees this is dated 37 2000 39 2008. This document that your lordship saw right now. This supplementary affidavit in opposition to the supplementary.
Yes, page 17.
Page 17, your lordship has seen. This is an admitted document by them. In this, there are two parts. One is then them giving the signature on a document.
I'm not on that.
No, kindly see the next part. It will get clear. The fact that they started communicating from 2008. Subsequently, 20th September 2008. By then, almost half the work was done. But I didn't require, with greatest respect, if I was choosing someone else also, I did not require to forge a document because I would have just ousted one and taken somebody on board.
You please try to understand.
Yes, my lord, I'm sorry.
What I'm asking you is, when they could not perform,
yes,
when they could not complete their part of the work, and now they are saying they have not introduced.
Yes.
According to them, they have not introduced Shopon, what is it? Mojumdar.
Shopon Mojumdar.
Right.
Yes.
So that irrespective of their agreement,
right.
Let's say they did not enter into an agreement.
I follow. Let me see what documents are.
So when you are inducting somebody in somebody else's place, you must have issued a communication.
If there is a correspondence to that.
Yes.
Well, it gives me a minute.
Because on which basis have you asked them to perform? And on which basis did you disburse the amount?
That everything is here, my lord. I'll tell your lordship because the bill started coming from, if your lordship sees, page 69. This is where the bills start coming from so far as Technicians Guild is concerned. If your lordship is wanting a specific document.
I'm not on bills.
No, and they start, Technician Guild starts communicating fully. Because we started having trouble with Technicians Guild also, which would come up in page 71.
You please go through it once again.
Very well. I understand what your lordship is indicating. Well,
because there are certain accounts also.
Yes.
Right?
Yes, yes.
You are also accountable for that.
Yes, yes.
Right?
Yes.
So, if you had entered into
I follow what your lordship
an agreement with X.
Right.
Suddenly Y comes into the picture. So how do you accept Y into that
because
in your scope?
Because of page 79. Because of page 79. Because Y disappeared, did not come back to work, and this is the document which.
So that is there. They have issued no objection.
Please appreciate our situation, my lord.
Sir, GWRL.
Vice President GW. This is Garware.
Garware.
It's been written to us.
It was written to you
by Technicians Guild.
Did you endorse them? I mean,
endorse them, definitely. because these documents are,
I can understand
Yes.
that they had
They're
given you
stepped in.
this document.
Yes,
So based on this, you have
disbursed
ensured
payments.
that payments will be released in favor of
Yes, MEMCON. No,
MEMCON,
no, Technicians Guild.
Technical Guild.
Correct. Correct.
I also agree that all outstanding as on date will be
Have to be
will
paid
have to
to
be paid to
MEMCON.
MEMCON, not to
Yes,
Technical.
which is also and so and so.
The
With this
details of
norm
which
fee
is
and the Technicians Guild will not have
annexed
any
in
claim.
NOC,
Correct.
and technician will not have any claim on such and such against the work order,
Sorry, MEMCON
since
finished.
the
We paid
outstanding
MEMCON.
payment is to be released
The
in
names,
favor.
I thought MEMCON was the other guy.
No,
Correct. Yes.
now this is what you received from Technical Guild,
Yes.
right?
Yes.
So you are saying that you have acted on the basis of this, but did you give them any kind of written document? I mean, did you address them that we accept your proposal, giving a copy of that to the MEMCOM? No.
Why do we need to? Because the agreement is already there. MEMCON was already working. Technicians Guild, we are having problem with. It is evident from page 69 onwards. MEMCON is already there.
So why don't you? MEMCON came into the picture prior to this NOC.
Yes, much prior, because MEMCON and Malad, this is the reason why page 56
Then
becomes.
why are you showing me 79, sir?
Malad, I've understood. I've understood.
Why are you showing me 79?
Why I'll tell your lordship is because Technicians Guild was.
I'm not on the portion where you have disbursed them the money. I am on the initial induction. There was an agreement between Technician Guild and MEMCON,
Yes.
right?
Both come together.
Both come together.
Yes, Technicians Guild taking the front lead
Right.
role.
Then they say that MEMCON will do the work, and you disburse this amount which you ought to have disbursed in our favor, in
favor of Technicians Guild to MEMCON.
MEMCON.
Yes.
Right. Now they place that agreement before you.
Yes.
They place it before you.
Yes.
Have you issued any document
to MEMCON?
To MEMCON, stating that based on this mutual agreement, we are inducting you. That you are stepping into the shoes of Technician Guild.
My lord, I think there is only one issue over here. Whatever your lordship indicated, subject to what would fall subsequently, my lord, Technicians Guild, as I said, was playing the lead role.
Because first of all, try to understand why. Now, you have to clarify them. They are saying that you on your own got a third party into it.
Which we couldn't have because of the agreement.
So that's exactly what I'm saying. That apart, this agreement is between these two people.
Yes.
Right?
Yes.
This agreement was shown to you.
Yes.
Right? And then you take the action forward.
No, my lord. This is possibly where I'm trying to indicate to your lordship. This agreement is produced. Now, what is very important is the date 5th June 2007. Right? The work is on. MEMCON as well as Technicians Guild is working together. Technician Guild subsequently takes a backseat. MEMCON starts working further. We did not have a cause to doubt MEMCON because they were already there along with this. And we have known them to be on board on prior date. Technicians Guild continues to write to us, which your lordship would see, page 67.
But then this is contrary to what you said.
My lord, kindly appreciate, my lord, what they are
This
stating.
is this just a minute. This is how. Why is because this agreement, my lord, right now they may say something which is contrary, but this
so you mean to say both the Technician Guild
and MEMCON
and MEMCON they were working together.
MEMCON has come in through Technicians Guild and have already been in the scene. That is the reason why on 30.
So they were the subcontractors.
Sub. MEMCON is the sub. MEMCON is under him. And that is the reason why when Technician Guild stops, we don't have anything to do with MEMCON. We had nothing to do with MEMCON. But MEMCON introduces, Technician Guild introduces MEMCON. And then MEMCON continues to work so long as our work is being done. Now, subsequently, this NOC comes up. Says that whatever payment you have to do to us, you give it to MEMCON. And then ultimately we pay MEMCON. And finally we are being held responsible. Yes. Yes, in fact, page 17 shows that, that this person, Shopon, whoever's there, what is his name? Shopon, right? Shopon Mojumdar. Well, that your lordship will see, he admits over there in that document, the long-standing business partner. So this is a regional issue. I'm a national company. I have come into this region to get a job done because I've got the contract. These persons fighting amongst themselves, who's producing NOC, who's producing what? So how would the managing director of Garwari get roped in, my lord? There might be a dispute between MEMCON and the word is, I would like to inform the above same Shopon Mojumdar is originally the partner of MEMCON, but before various authorities, he's representing himself as the proprietor. And I have long business relationship with him. Now, does this find any reference to the complaint? And does he say that he has had a long-standing business relationship? I am a person from Pune. How will I know what kind of relationship he is having? They are showing me agreements. These persons stopped working. Technicians get stopped working. MEMCON continues. There is no objection placed. I disburse the whole payment to MEMCON. And how?
So it's not that MEMCON was not there from the initiation.
No, MEMCON comes in. MEMCON gets introduced while Technicians Guild is working. And that is evident from the agreement itself. That is why, my lord, with
This
greatest
agreement between them
yes,
was signed after how long?
Agreement.
They had been working.
Yes.
Later on, they entered into this.
Not later on. From us, for us. Just a minute. The court is asking something else. This agreement.
No. You said that both of them were working together.
Yes, yes.
Right?
Yes.
So when they were working together, there was no issue.
No, we don't know that whether there was issue or not because it does not pertain to us. Yes, there was no issue. When MEMCOM is in scene, Garware is, but Technicians Guild is going out because MEMCON continues.
So after what period this happened?
Work contract কবে issue করেছিল?
No, May is the work order which is dated, which is page 25. 25 of what? Of the reply. They only say this. May, page 25, and June is when they.
You had been the contractor. Technician Guild had been the subcontractor. MEMCON had been the subcontractor.
Yes.
Right?
Yes.
Now this Technician Guild and MEMCON,
yes,
they were continuing the work.
Yes.
They were continuing.
At what stage the dispute arose?
At what stage did they sign that agreement? Though they are disputing it, that we have not signed.
After the work order is issued.
So what is the gap?
1 month. No, not even 1 month. May 1 month. 2nd May 2007.
When did you get the work order?
No. When did I get the work order? This work order is being given to Technicians Guild on 2nd May 2007.
When did you get the work order?
I'll have to clarify that. When did I?
You clarify these issues. Mr. Banerjee, listen to me.
Yes, madam.
When you got the work order,
Very well.
when did you give subcontract to Technician Guild?
2nd May. Right.
2nd May.
I'll make a list of dates.
Right. 2nd May.
Very well.
Then from 2nd May onwards, Technician Guild as well as MEMCON, both of them were working.
Yes.
Right?
Yes.
Then they enter into this agreement.
Yes.
Right?
Yes.
Now in page 66, they have given a chart
Yes.
as to the amount disbursed by you.
Yes.
You act on
Yes.
the basis of the letter
Yes.
given to you by Technician Guild
Yes.
with regard to that NOC.
Yes.
That date.
Yes, my lord.
Right?
Yes, my lord. Yes.
So initially they can't say
Yes.
that they were not aware of it since they were working together.
Yes. By their documents only.
Right.
Yes.
Now, if there had been a dispute between what is it?
Technicians Guild and MEMCON.
Technician Guilds and MEMCON.
Right.
They have to show your role in it.
Very well. I've understood exactly what your lordship is saying. Well, it keeps it next Thursday. I will.
What is your role in it?
I
right?
don't know.
Whether you introduced MEMCON without their, without the permission of the Technician Guild,
Can
or Technician Guild introduced MEMCON
right.
without your permission. If at all that was done, whether you were in a position to permit, would you have been
Yes.
in a position to give permission to MEMCON to work unauthorizedly?
That was not an issue.
I'm asking you, why don't you give me an answer?
But but may I take the first question first?
Yes.
The first question was introduction of MEMCON. Whether I introduced MEMCON or not. A is that I'm not a local person at all. I am a person from Pune. I'm a company who's a multinational company. I come in and evidently, admittedly, in terms of page 17, they are business partners. So by your lordship can infer.
You give me the answers
Yes.
as well as he gives me the
Very well.
answers.
Very well. I've
Because
understood the questions.
he has said
Hmm.
that they are not aware of MEMCON.
This is showing from their documents. What will we say?
I don't know.
It
This
is
is
their
what he said.
opposition.
This is what he
Okay,
said.
my lord, I'll do something.
I have asked a
Yes.
common question.
Yes, my lord.
Common to both of you. Right? So they are denying the agreement. They are denying the NOC. They have not introduced MEMCON. They don't know who MEMCON is, right?
My lord.
Then is it
Yes.
your role to have introduced MEMCON
Then why would I?
unilaterally?
I can. That would be, for a minute, accepts that position. I can. What would it happen? That I am violating a condition, an agreement condition. But for that, I don't need a no objection. I will say, you've not worked, you've not paid, go. I will deal with you in a civil court. I don't need a no objection to pay MEMCON. Two persons working for a multinational company
That is something I have understood. You need
So
not.
I had no reason to do it. My lord, the question which your lordship has raised, one after the other, I will indicate from the pleadings as to how they knew MEMCON, A, what are the documents supporting that, and how they are taking contradictory stance. I will give that in a sheet of paper to your lordship on the next day.
And sir, correspondingly, you also say that you did not know MEMCON,
My lord.
right? And you never worked with Technician Guild from the very beginning.
No, he's
In
Technician Guild.
respect of this work contract.
Is
In respect of this
you
work
did
contract.
not work with MEMCON at any point of time.
My lord.
You, what is that person's name? Shapon Mojumdar.
Shapon
Mojumdar.
You were not aware of him?
No,
I have not stated that I am not aware of Shapon Mojumdar. But the thing is that
Sir,
whether he
you
was
just now
engaged
said,
in work
you
contract
just
or
now
not.
said that you did not know
My lord,
MEMCON.
I did not know about the MOU and the NOC.
Ah.
I did not know about the
Please
MOU
state
and the NOC.
You did not know about the MOU and the NOC.
And the NOC.
Okay. So, but you never worked with Technician Guild.
No, he's Technician.
I am the technician guild. My lord. I have
You
never
never worked with MEMCON.
with respect to this work contract.
Yes.
Never.
You never worked.
Never.
Now they used to work, that means let them give
Even if, for the sake of argument, let us consider that I was working with the MEMCON. That doesn't, if so, fact, to give them a power to disburse my amount to a third party MEMCON, because from their statement itself, it is evident that NOC was introduced by the MEMCON, a third party, to them. And on the basis of that NOC, because this NOC was not produced by me, I didn't go to their office and I didn't produce this NOC to them, stating that, look, this is my NOC and you pay my amount to them.
So
This is their document where
they
they
had
have realized.
forged that NOC.
No,
My lord, they have, my lord, whether they have forged.
No, but the NOC was issued by Technician Guild.
My lord, now, my lord, kindly consider, repeatedly this has been forwarded, this has been submitted to your lordship that they
Technician Guild only has issued that NOC.
My lord, Technician Guild has issued no NOC. If the signature, for the sake of argument, if the signature is taken by force or by compulsion or by any by coercion or something otherwise, and it is being produced to them, because this is evident from the document itself. I have never produced this NOC to their office. Repeatedly I'm saying this NOC was completely foreign to my knowledge. Completely I was unaware of.
So that's exactly what I'm asking you. Your claim is that the NOC that has been issued,
my lord,
in your letterhead,
my lord,
had been forged.
My lord.
Yes, you have forged it.
Right. Now, my lord, they are stating repeatedly that they are not the beneficiary of this forgery or the 420-406, whatever it may be. They are not the beneficiary. Now, my lord, kindly consider one little things. If the technician guild is deprived of the entire situations, who will be benefited? Just simple as the motive behind commission of an offense. Who will be benefited? It is none other than the Vayu Garbhati. Because now, my lord, the initial work order was issued by the irrigation department. This is my contention that I have successfully completed my work. I have completed 130 geotubes whereas the order was given for 120. Now, on the basis of the same, irrigation department has disbursed the amount, contractual amount to the Biogarvare. Now, if I have been deprived of, then ultimately who will be benefited? It is the Biogarvare, none other else. If a third party can be bring
Just
in
ask
between,
him why is he
and
Memcon a party?
instead of
Why,
paying,
if I am the only person who's going to benefit,
But then you can,
what?
You must be having documents through which you can show that you have paid to Memcon, or else you did not
I
pay.
have annexed to the.
So he is saying that if you
That
have
I have
paid
benefited.
if you are paying to Memcon, then who is benefited?
Then who's
1
benefiting?
crore 50 lakhs rupees, so far as my knowledge, my lord, is still due and payable.
Why knowledge? We are on records right now.
Total number of work contracts, out of which if they are paying 12 lakh rupees to the Memcom, then the entire amount is settled.
So what is your stand?
Correct.
Are you against them for forgery or cheating or whatever? Or are you on the point that you claim certain amount, you have not received
My
that?
simple contention is that by using two documents, MOU and the NOC, I have been deprived of and I have been thrown out from the work contract. And my amount has been paid to a third party. So I am solely concerned with that regard, that let this matter be cleared out, this matter be remitted back to the lower court for a fresh inquiry, that who are behind the scene, behind the curtain, that who have manufactured this document. And
So where is your Memcon?
My lord, this is their petition. They were required to produce Memcon before.
Why?
Before, my lord.
Now your lordship has
Otherwise,
understood.
their petition
He
is gone, my lord.
admits, for a minute, let us see. He admits that 100 rupees non-judicial stamp paper is put his signature. He admits to have put his signature on an MA paper.
I have
He
not
knows,
admitted anything.
my lord, he has admitted over
I
here.
have not admitted
He has admitted over here. I am talking about a
Even the
document which.
signature is taken
My lord,
under
he's-
any kind
my
of.
lord, let him just say how he has. This is his document, not mine. He has produced these documents.
I also put my signature.
This is his signature. He has produced this document. This is his
How
filing,
on the
not
basis
mine.
of a foreign document they can disburse the amount?
Foreign document. Why are you?
NOC was not given to them. This is their statement. Kindly come to
Just
page
ask them
number
why
10.
have they made Memcon a party?
My lord, kindly
Just ask them.
kindly come to page number 10 once.
You have to be,
My lord,
both of
just
you,
one.
both
No
of
suit
you.
filed. And this
Both
also
of
filed after 3 years.
This
Okay,
suit
both
file
of
is
you,
not a
sir,
ground for question.
Just
listen to
imagine.
me. Both of you get yourself confined
Yes.
within the elements of
Yes.
420, 468, 471, 466.
Grateful, my lord.
Okay?
But solitary confinement will do. I would choose that for a while.
Now, I believe the questions that I have asked
Shall be answered.
are
Are
pertinent.
effectively answered. If we are wise enough to understand this, they've stood answered. Even if I don't give that sheet of paper, it is stood answered. However,
My
my
lord,
lord, for your lordship's satisfaction, I will make a sheet and I will demonstrate as to how and where all he has stated.
my lord,
He's very angry. Why have you paid to Memcon?
And then he says, I have forced for my personal
Obviously, my
benefit.
lord, this is my fees which is being compromised.
Your fees.
I'm compromised from my fees actually from the
So
payment.
that is why you are arguing just to get extract fees.
Grateful, my lord. Keeps us up to 2 weeks on a fixed day at 2 p.m. so that we can just give the note and we can finish it up. Because the more we argue, the more we'll be churning curd. And we have a set of judgments also. We'll
But
keep a copy.
still now, my lord, there is a question that whether that NOC
I'll answer that. I will answer that.
that was communicated from our end. The NOC was communicated from our end.
This was in any case hard in part.
Yes, yes. No, but there has to be an order, my lord. Otherwise, my hearing will not take place. But I have a great person standing behind me. Below the all ball has come fully. So I do not know what he plans to do.
Advocates representing both the parties.
अभी 1 week पहले हो गए.
Next
Yes.
date be fixed on
Yes.
10th of September.
10th of September.
My lord, let it be after 13, my lord. I'll be out of station, my lord. For from 9th to 13th, my lord. Let it be on 15th.
15th.
Where is the other person?
Which one?
There was
He is
another.
Samuel, my lord. My senior is Samuel, my lord.
I was thinking he is coming. So that's why I chose solitary confinement.
16th of September.
16th of September. Grateful, my lord. Grateful.
Wait, please, your ladyship, my lord. 158, sir.
Who is your other side?
But Mr. Otharup Banerjee and Mr. Orijit Mojumdar were representing the union. The Pathan matter, my lord. Now, the matter, when it was being previously heard by the Honorable Justice Raja Basu Chaudhary, the union, the railways, was directed to produce the original broadsheet. The railways could not produce the broadsheet. Therefore, my lord, this particular order was passed on the 5th of February 2024, wherein his lordship was pleased to
In view of failure on the part of the respondents to
Yes.
produce the broadsheet, the writ petition shall
Yes.
be heard on the basis of it.
Yes, my lord, I have a
Yes, tell me.
quick response to it. My lord, kindly takes. I am essentially praying for, my lord, implementation of 2 division bench judgments, my lord, which is, my lord, also applicable, my lord, squarely in the facts of my case, my lord, arising out of the same, my lord, selection process. My lord, kindly takes pain to come to page 90 of the writ petition. Your ladyship will find that I have annexed, my lord, a copy of the judgment and order passed in, my lord, APO number 679 of 1998, dated 21st of February 2012. My lord, the broadsheets, my lord, which were not available, which the union or the railway said that are not readily available. If my lord now kindly takes pen to come to page 92 once.
No, it was dismissed.
No.
Page number 90.
Page 90 was an appeal against the order of the dismissal of the Honorable Single Judge.
Yes.
Thereafter, the appeal was allowed, whereby the writ petition was also allowed.
Okay.
Now, my lord, kindly takes page 92 for once.
Yes.
The last paragraph. Our attention is drawn to the broadsheet produced by the respondents before the Honorable Single Judge in their affidavit in opposition. From the said broadsheet, it appears that the writ petitioner number 1, namely Rajesh Kumar, secured 160 marks in total. The writ petitioner number 2, namely Manoj Kumar, secured 163 marks in total. And the writ petitioner number 4, namely Dileshwar Kumar, secured 165 marks in total. Now, my lord, this is the broadsheet, my lord, which the railways has failed to produce. My lord, I have annexed a copy of that broadsheet only in page 67.
In this matter, this APO.
Yes, APO was, my lord, it went up in appeal, my lord. I understand it was filed in the original side, my lord. So, but in appellate side, my lord, it's MAT, and in original side,
I'm not on that. The names of the petitioner are same.
no. I am a similarly circumstanced petitioner who was a participant in the same selection process.
Okay.
My case is, my lord, I have secured more marks even.
Here it is Rakesh Kumar.
So, my client is, my lord, Yogesh Mishra. So, my lord will find, kindly takes pain to take, my lord,
And who is appearing for the others?
my lord, Mr. Autorup Banerjee and Mr. Orijit Mojumdar.
No, you are saying Yogesh Mishra, but I find here Rakesh Kumar.
No, this was, Yogesh is my client, my lord, the present
Prabir
petitioner.
Sengupta and all.
No, Lord, Yogesh Mishra is the writ petitioner in the writ petition which is before your ladyship. Here, my lord, I am relying on 2 division bench orders, my lord.
So that is all mentioned.
Yes. So if my lord kindly takes, my lord, pain to take the broadsheet at page 67.
Yes.
My lord will find against, my lord, these names, my lord, which I just read out, that is Rajesh Kumar, Manoj Kumar, and Dileshwar Kumar. My lord will find their names as against, my lord, serial numbers 8, 9. 8 is Rajesh Kumar. Rajesh secured a total of, my lord, 160. 160, no, 160, my lord.
169.
169, yes. Thereafter, Manoj Kumar.
163.
Yes, Manoj secured 163, and Dileshwar Kumar. Dileshwar is at serial number 12. Dileshwar secured 165.
So now the remarks are F.
F, failed. I'll come to that. My lord, before that, the present petitioner's name is again serial number 14. That is Yogesh Mishra. Kindly marks, my lord. He also secured 166, my lord. That is, my lord, the marks, my lord, beyond the marks secured by Manoj Kumar and Dileshwar Kumar. Because Manoj secured
163, 165.
My lord. Now, here what happened was, there was an appointment process, my lord, a recruitment process which was initiated by the railways. The recruitment was, my lord, to the post of sub-inspector executive in the RPF, in the Railway Protection Force, and the Railway Protection Special Force. Now, it was stated that the candidate, in order to be successful, has to secure a total of 40% out of 300 marks. Now, thereafter, my lord, once the ball started to roll, once the recruitment process started, suddenly, my lord, there was a change in the rules of the game, and the recruiter, the employer, being the railway authorities herein, they came up with the, my lord, precondition, or rather, my lord, a subsequent condition, which was never even intimated to any of, my lord, the participants in the selection process, that no, you should not only secure 40% marks in its totality. I mean, not only in the physical and interview combined, you have to separately secure 40% in the interview, that is in the viva voce, which is of 100 marks. And thereafter, my lord, this particular thing happened that persons who secured more marks than the other incumbents, against them, my lord, the remarks, if that is fail, my lord, those were endorsed. So the Honorable High Court was moved by, my lord, some of the my lord, unsuccessful candidates, my lord, that they have changed the rules of the game after the game commenced. The Honorable Single Judge, initially in one matter, allowed the writ petition directing appointment to be granted, my lord, to the petitioners therein. The railways went up in appeal. Now, the Honorable Justice Bhaskar Bhattacharya, my lord, have also annexed that order. The division bench, my lord, presided over by the Honorable Bhaskar Bhattacharya, as his lordship then was, my lord, was pleased to, my lord, affirm the order passed by the Honorable Single Judge, allowing the writ petition. And, my lord, in the other judgment, my lord, that I had just pointed out, page 90, in page 90, my lord, the Honorable Single Judge was pleased to dismiss the writ petition. From that, my lord, the unsuccessful petitioners went up in appeal by assailing the order. The Honorable Division Bench, my lord, allowed, my lord, the appeal and allowed the writ petition directing appointment to be granted to the petitioners, my lord, / appellants therein, my lord, in connection with these recruitment process, my lord. Now, thereafter, my lord, a special leave petition was filed before the Honorable Supreme Court of India also by the railway authorities. I have also annexed that. The Honorable Supreme Court of India, my lord, also did not interfere with the order passed by the Honorable Division Bench. The railway carried the order to the Honorable Supreme Court, which was passed by, my lord, the Division Bench, presided over by the Honorable Justice Bhaskar Bhattacharya. So that, my lord, will find that judgment dated 16/6/2011 is at page 38. But your ladyship may not delve into, my lord, the judgment. It's quite my lord, a lengthy judgment. Instead, my lord, the other judgment at page 90, my lord, if I place that particular judgment, that squarely covers, my lord, the relevant portions of the first judgment, my lord, which was delivered by the Honorable Division Bench, presided over by His Lordship, the Honorable Justice Bhaskar Bhattacharya. But may I just place, my lord, the judgment at page 90. So, Mr. Sachin, senior advocate, has handed over 2 sets of compilation of papers. But I'm placing from page 90. Yes,
There was a judgment,
my lord.
I believe, of Himani Malhotra. There it was mentioned that there cannot be any fixed marks for viva voce.
Oh, my lord, all those judgments were, my lord, were considered by, my lord, the division bench, my lord. In the first, I'll tell you, ladyship. Page 38.
I mean, if my memory goes right.
Your ladyship has a photographic memory, is all I can say. Here, a number of Supreme Court decisions were cited. Yes, my lord, kindly takes page 50.
50.
My lord. Where, my lord, Himani Malhotra was cited.
It was cited?
My lord, I reiterate, my lord, that my lord's memory is photographic.
Oh, no.
For the same proposition, the appellants had also relied on the decision of Himani Malhotra versus High Court of Delhi, reported in AIR 2008, Supreme Court, page 2103.
Yes, page 90.
Page 90. And this is an appeal against the judgment and order dated 13th August 98, passed by the Honorable Single Judge of this court in writ petition number such and such. By the order impugned, the Honorable Single Judge dismissed the writ petition. The writ petitioners were applicants for selection in the post of Sub-Inspector Executive of the RPF, Railway Protection Force. All of them participated in the selection process, but they were not selected. The main grievance of the writ petitioners was that although selection was proposed to be held on the basis of a written test, physical efficiency test, followed by viva voce test, in the advertisement there was no indication that there would be a qualifying marks in the viva voce test. The authorities prescribed 40% marks as cut-off marks for the viva voce test for selection. None of these petitioners admittedly secured 40% marks in the viva voce test. However, similar question cropped up in various writ petitions, and ultimately a division bench of this court considered the matters in details in FMA number 577-578 of 2005. By the judgment and order dated 16 June 2011, the division bench inter alia held that a prescription of qualifying marks not made known to the applicants was in effect an ineffective prescription. A prescription that existed on paper and kept obscured from the knowledge of those to whom it mattered was an apology for a prescription of minimum marks for the viva voce examination. The confusion was worse confounded by the fact that the employment notification mentioned qualifying marks for written test. The division bench further held that the prescription of qualifying marks in an undisclosed circular was a stale one, and prescribing the cut-off marks as additional qualification during the selection process was bad. Therefore, the division bench directed that all the writ petitioners should be given appointment as they were not selected on the strength of undisclosed qualifying marks at the interview. It was found those persons who secured lesser marks than the said writ petitioners were appointed. However, the division bench held that as the selected candidates were not made parties in the writ petitions and as they were working for more than a decade, they should not be disturbed. However, the authorities were directed to give appointment to the said writ petitioners if there be any vacancy, and in the event of non-availability of the vacant posts, they should be appointed in the next available vacancies occurring in future within 2 months from the date of such vacancies. It was made clear that the writ petitioners would not be entitled to seniority or salary with retrospective effect. Their seniority should be reckoned and their salary would be paid from their dates of appointment only. We were informed by Mr. Gupta Larner, senior advocate appearing for the appellant, that the respondents approached the Supreme Court of India challenging the aforesaid judgment and order passed by the Honorable Division Bench dated 16 June 2011. The SLP was registered as SLP number such and such. By order dated 17th October 2011, the SLP was dismissed. There are 4 writ petitioners. Mr. Gupta Larner, senior advocate, submits that already the writ petitioner number 3, namely Muhammad Tariqat Ali, is not interested in as much as he has already secured employment in other field. Our attention is drawn to the broadsheet produced by the respondents before the Honorable Single Judge in their affidavit in opposition. From the said broadsheet, it appears that the petitioner number 1, namely Rajesh, secured 160 marks in total. The petitioner number 2, namely Manoj, secured 163 marks in total, and the petitioner number 4, namely Dileshwar, secured 165 marks in total. Still, they were not appointed as they failed to secure 40% marks in the Viva-voce examination.
Now, they were supposed to secure 120. You said 40.
Out of 40% of 3, yes, 120,
300.
yes. So our attention is also drawn to the fact that some of the persons who have secured less marks than that of the writ petitioners have been selected as they secured more than 40% marks in Viva-voce examination. Therefore, we set aside the order impugned and allow the writ petition in part and direct the authorities to appoint the writ petitioners number 1, 2, and 4 in the posts of Sub-Inspector Executive RPF against the future vacancies within 2 months from the date when the future vacancies occur. However, they would not be entitled to seniority or salary with retrospective effect, and their salaries shall be paid only from the date of appointment. The appeal is just allowed with the aforesaid directions. But here, I was also a participant. So I had, my lord, previously, my lord, the only point that they can take, my lord, the respondents, is the ground of delay, my lord. Since, my lord, it is my duty to indicate, my lord, what can go against me, my lord, or what can be their defense. But I have specifically pleaded in the writ petition also, I have explained the delay by stating that, my lord, I had approached the honorable, I am a resident of Uttar Pradesh, my lord. I had approached the petitioner, appointer. I had approached the learned advocate. I was made to understand that it kindly takes page 24. But kindly takes page 20. I'm sorry, my lord, page 23, paragraph number 23 and 24.
Yes.
I will not be placing that, my lord, since I understand it is being, my lord, streamed, my lord. It is explained, my lord.
So after how long did he file this?
No, my lord, what happened was, my lord, kindly takes page 78. These are my representations, my lord. This is dated, my lord. The first of the representation is dated 5th of September 2011. I had narrated the entire facts again, and I had also prayed for, my lord, similar treatment.
You had quoted the
Yes,
judgment.
yes.
So this was in which year?
This was in 2005-9-2011. And there were, my lord, follow-up representations, which your ladyship will find at page 83, dated 18-9-2011. 84, that is 2nd of October 2011. Thereafter,
Did they reply?
no, nothing. Thereafter, my lord, page 85, 24-10-2011. And finally, my lord,
Then you filed this in the year 2012.
I filed it in 2012. By then, in
Against
fact, my
the,
lord, by then the judgment that I had just placed, my lord, that is the one at page 90, the order dated 21/2/2012. My lord, in fact, my lord, I had, my lord, started giving representations immediately after passing of the division bench judgment, the first one, my lord, that is 16/6/2011. Because, my lord, by then, my lord, 21st February 2012, my lord, was not there. I filed it in 2012, my lord, this writ petition.
and
But
the,
I say, but my
it was, the employment notice was of the year 2000.
it was of 1997. 1997. Here, my lord, technical objections will not be a bar. It's a legal submission, my lord, that I am making. In view of the fact that, my lord, here no third-party rights have been created. As also, my lord, observed by, my lord, the Honorable Division Bench in these two appeals, my lord.
What is your age now?
I am presently aged, I'll tell your lordship. I am aged, 49. 49. 49. I do not claim any seniority, any back pages, any, my lord, anything. I want, my lord, a treatment akin to the treatment as regards the other participants, my lord. My lord, here, your ladyship may kindly make note of the fact, my lord, that there is no third-party right, my lord, which will get affected or which has been created. Because, my lord, the Honorable Division Bench in the previous litigations, my lord, concerning the same selection process, has carved out an exception as regards the procedure to be adopted. So here, my lord, none of the persons who are already, my lord, appointed will be affected, my lord. Second is, my lord, it is not a case, my lord, that my other legal right has been affected. My case is squarely a case covered under Article 14 of the Constitution of India. Article 14 states about, my lord, equality of opportunity. Can I have a constitution?
Okay, sir, what we will do is,
No, I'll just cite a decision of the Honorable.
you do that on the next date.
Very well.
I'll give them one last chance. If they appear fair enough on that day, I'll fix it up for orders.
What may I just avail of this opportunity of coming up with a very short note on, my lord, what I argued, my lord?
You can. For the submission of learned advocate representing the
Because the
petitioner.
older this gentleman is getting, the more impatient he is getting. It's an unfortunate case.
None appear to represent the respondent railways. Next date we fixed on the 9th of September.
9th September?
As last chance.
Very well.
If they appear, fair enough. If not, you can file your written notes over time.
Extremely grateful to you. I am grateful for the patient hearing, my lord, or for tolerating me, my lord, for so long. With your ladyship.
Sure. No, we have to keep wakalatnama.
It is for a little typographical error, my lord, it has come up before your lordship.
তাহলে ওরা কোথায়? ওরা একজনও নেই? No, which paragraph?
Page number 4.
What it will be?
My lord, your lordship will kindly see paragraph number 9. My lord, this fifth line from Vishnu. My lord, fourth line, the last word Vishnu Bosak. Lord Vishnu, appellant number for Vishnu Bosak. Lord Vishnu Bosak had died earlier, and Lord his. এটা বিশ্বনাথ বসাক হবে Milord, your lordship had earlier disposed of Quen 2. This Vishnu Bosak should be named as Vishwanath Bosak.
Only this much.
No, Milord, there is another one, Milord. Milord, then the very next line, Milord.
What is the spelling of Vishwanath?
Biswanath.
Vishwanath Bosak.
Lordship.
Yes.
And thereafter, your lordship will kindly come one line thereafter, starting with Milord, identification of the appellant numbers 1, 2. Milord, 2 should be 2 had died, Milord. Instead of 2, 3 has come up.
1, 3.
1, 3, and 4.
Okay.
And Milord, the last sentence of this paragraph number 9, Milord, the last line mentioned in the CAN application being CAN 2. Milord, this CAN 2 is in actual CAN 3. These 3, Milord.
Okay.
Extremely grateful to your lordship. Okay. I'm obliged to my lord.
My lord. Matter, my lord. The petitioner has died, my lord. My lord, I need certain information from the sons of the petitioner so that further substitution petition may be done, my lord. The petitioner died, my lord. I got the information very recently, my lord. There is an order to file the paper book, my lord, but it can't be done as.
First of all, madam, you need to be called.
My lord.
So you should have been vigilant enough.
My lord, I was engaged. I'm extremely sorry, my lord. I was
It
engaged in
happens in every
court number
matter.
2, my lord.
Appeal.
My lord.
I'm lenient, but that doesn't mean that you will take
My lord,
advantage of it,
from
madam.
now onwards, I'll be there, my lord. I'll be there.
Not a single date.
My lord, in the month of December or January, my lord, otherwise.
Let it go out of the list whenever
Liberty
you
to
are.
mention then, my lord.
Ashwin. Now in any the
In
other
the month
matters
of
also,
November,
when
my
I
lord.
see your name. Appellant died?
My lord, I have heard in the last year, my lord.
Last year?
Yeah, my lord.
So how long this matter is
My
running
lord,
in the list?
when the paper book.
At least of. Madam, if the claimant had expired last year.
My lord, there is no, they did not contact me in this period, my lord. And when to file the paper book, then I have come to
Let
know
the
that.
matter go out of the list.
I had liberty to mention, my lord.
You do whatever you have.
My lord, liberty to mention. My lord, kindly.
The way you people deal with the claimants, just see. The claimants are suffering.
My lord.
I don't know what personal equation you have with the claimants.
No, my lord.
That is why.
No, my lord.
With the liberty to mention Kurdi.
Get me.
Yes, sir, the person is not there. They had to file the wakalatnama. I had asked them.
Petitioners. I'm on the respondent bank. Petitioners have the respondent.
Ashwin. The learned advocate. None appeared to represent the petitioner. The learned advocate representing the respondent bank is present. They probably must not have filed the wakalatnama. Let the matter be dismissed for non-prosecution. Next. Next.
75 is coming.
Next.
Lord, ATP is the insurance appeal. Lord, pursuant to my lord's earlier direction, my lord, for preparation of paper book, my lord. Lord, I have received my lord all documents now. My lord, within a day or two, my lord, I'll file my paper book. My lord,
Which one is this?
my lord, 83, my lord, insurance appeal.
Who was appearing for the
Lord, one
respondent?
Subhashish, I saw him, my lord, he was there. Subhashish Ghosh was for the claimant. Lord, he was there outside with me, my lord.
Mr. Singh, for your case, since you're a regular person every day, today I have adjourned the matters.
I'm extremely grateful to you.
Now, when your matter is called, you have filed the paper book.
Lord, I shall be filing, Lord, by tomorrow or the day after. Lord, I've got the documents now.
On the prayer of the learned advocate representing the appellant to file the paper book. Next date be fixed on 26th of August.
Yes. Just sleep.
The learned advocate representing the respondent claimant is present. Next. Again, you have to be called.
Yes, sir. Yes, sir.
Bless your lordship, Lord. Lord, 84, I'm for the respondent insurer.
The appellant, your lordship.
Lord, this claim case was dismissed on the ground of non-involvement of the offending vehicle in this case. Lord, my learned friend on the last date, my lord, had come up with another copy of award of a same, in arising out of the same case, my lord, insurance company had satisfied another, my lord, claimant. My lord, he gave me the copy. I inquired from my client, my lord, that in this case, yes, Another victim, my lord, was satisfied. If, my lord, another victim's, my lord, award was satisfied, then, my lord, the involvement of the vehicle, my lord, is confirmed, my lord. So, my lord, I shall not be, my lord, troubling your lordship as far as the involvement part is concerned.
So I'll fix it for orders.
Fix it up for orders, my lord. Grateful to your lordship.
Heard the submission of learned advocates representing both the parties. Let state be fixed on 13th of November for orders.
13th November. Grateful to your lordship. এখন দিও না 13 তারিখে দিয়ে এটা একটা কপি আমাকে দিয়ে দাও draft my lord, item 85, my lord, is insurance appeal. On the last date, my lord, my learned friend, my lord, had taken leave, my lord, to file paper book. Paper books are ready.
I am filing.
My lord, this appeal is on the ground of, my lord, mainly non-involvement. Your lordship will kindly, my lord, fix it up for orders, my lord. On that day, my lord, I will get it disposed of.
আচ্ছা, এবার আমি যখন ফর অর্ডার্স গুলো ডিকটেট করব,
My lord is taking note, my lord, and it is on the ground of, my lord, driving license.
They have not yet given me the paper book. Paper book has been filed.
Yes, yeah, today he has filed, my lord. Today, just now.
Yes.
My lord, this appeal of insurance, my lord, is on the point of driving license and also on quantum. My lord, your lordship will kindly fix it up as for orders, my lord. We'll get it.
Driving license?
And also on quantum, my lord.
Driving license was invalid.
Yes, my lord.
Quantum, according to you, was excessive.
My lord, it was excessive, my lord.
Ashun.
paper book filed by the learned advocate representing the respondent claimant be kept on record. Heard the submission of learned advocates representing both the parties. Can it be fixed for orders?
Yes, my lord.
Next date be fixed on 14th of November for orders.
Grateful to your lordship. 14 November. हाँ. 88. Lord, 88 is, my lord, appeal of insurance company. My lord, my lord had asked me, my lord, to prepare the paper books in this case. My lord, I've got all the documents. My lord, one single document. My lord, I've got the depot. My lord, this entire exhibited documents series. My lord, the claim application. My lord, I've asked my client. It must be there, my lord, in their records. My lord, I'll get it, my lord, and I'll get the paper book ready on the next date. My lord, Lord, say kindly grant me some time. Otherwise, all, my lord, exhibited evidence. Evidence. Oh, evidence. আমাকে দিয়ে দাও না. My lord, exhibited documents are there.
You need the TCR.
My lord, I need the TCR. My lord,
Then you could have told it earlier.
my lord had granted me leave, my lord. That is why, my lord, I was thinking, my lord, I did not get it.
Now what? You need the
I
TCR.
need the TCR. My lord, the exhibited documents are here, but only for that, my lord. Deposition part, my lord, is required.
The learned advocate representing the appellant insurance company submitted to have received certain documents barring the documents pertaining to the
depositions and claim application
and sought for the TCR to be placed before this court. Full stop. The learned registered judicial service is to call for the TCR pertaining to the instant appeal from the court of the learned tribunal prior to the next date of hearing. Which place? Which place? Which district?
This is Paschim Medinipur.
Next date be fixed on 15th of September.
15th of September. Grateful to you.
99.
My appeal, Lordship. There is this, Lordship has called for a stamp reporter report, Lordship.
On first, তাহলে ওখানে 339
Yes,
days.
Lordship. Actually, Lordship, what happened, the trial court record was never called off, but the trial court record was misplaced, Lordship. Later on, it was detected that it already automatically came before this honorable court. From there, I need to collect the impugned judgment and order. So there was a delay, Lordship. As per your Lordship's earlier direction, I have already served upon the opposite party claimants and respondents. There is a delay. Can 2 is for the delay petition, 339 days delay, and can 1 is for the stay petition. I have already deposited the statutory amount.
ওদেরকে ডাকা হয়েছে? চঞ্চল বা শ্রীমন্ত?
Yes.
Next.
My lord, 99 is insurance appeal. On the
I am
last day,
appealing for the respondent claimant, your lordship.
on the last date, my lord, since the claimants were not appearing, my lord had directed the concerned police station, my lord, they have come from Uttar Dinajpur, Islampur, my lord, for to see to it that the personal appearance of the claimant is done. My lord, the concerned
He has
police
come, your
officer is
lordship.
here. My lord, the claimant is also here. My learned friend is representing the claimant. My lord, they have filed these reports. My lord, the police station's report, police officer's report. My lord, let just
Earlier they couldn't do it.
My lord, earlier they couldn't do it. My lord, only with, as far as the owner is concerned, my lord, owner, they say that the owner is in Bombay. So, my lord, they couldn't get hold of the owner. But, my lord, otherwise, my lord, the claimant is here.
I'm appealing on behalf of the owner.
Oh. My lord, let the report be filed. My lord, be kept with the records of the police officer's report. Concerned police station.
Which I filed one cross appeal, your lordship. That should be.
Earlier occasion, now he has been newly engaged.
He was not there on the last day. My lord, on the last day, first time, they all are waiting for the first time.
He's for the owner.
He's for the owner, yes.
Now, what about the claimant?
Mr. Banerjee is for
I am appealing for the claimant, your lordship.
You did not appear
No.
on the earlier.
Last occasion, I missed the list, your lordship. Kindly there. Last occasion, I missed the list, your lordship.
आप जो है पुलिस के डाकते हैं.
You must have seen the condition of the claimant.
Uh,
You must be knowing the condition of the claimant. Thereafter, you people do this, sir. I believe when you are dealing with this accident claim, realization, if not any এটার রিপোর্টটা কোথায়? And these kind of orders may appear to be stringent.
Yes.
But again, if not passed,
Had it not been there, then perhaps again, yes. They do appear to be stringent, my lord, but had these not been there, then today perhaps again, my lord, nobody would have been here.
nobody would have appeared.
Unfortunate. My lord, this appeal can be disposed of. This is only confined to quantum, your lordship, my lord. My learned friend will prepare, my lord, a very short paper book, my lord, and you can fix it up for orders.
Ashun. The report filed by the Register Administration, LOM, be kept on record in compliance with the earlier order dated
What is the
7/5/2025. The concerned police station had served the notice upon the respondent claimants and ensured the personal appearance of the same before this court. The personal appearance of the respondent claimant is noted and dispensed with.
Question my cross appeal.
Finish it off.
Yes, yes, my lord, I shall, my lord, your lordship will kindly keep, my lord, the police reports with the records of my lords.
Which one?
The police report, my lord, those were submitted before.
It is there. It has been
Question,
kept on record.
But personal appearance, my lord, exempted, my lord.
Yes.
Grateful, your lord.
My cross appeal be tagged, your lordship.
We learned. When did you file the cross appeal?
If I filed the cross appeal, uh, 23rd December 2024. I missed the list also. I candidly.
Did you miss the list, sir?
One day, your lordship.
What?
Your lordship.
রেপারকাশনটা অনেক উল্টো হয়ে গেল না, অনেকটা সবাই পুলিশ তো
I understand, your lordship.
Your name is Mr. Jayanto Banerjee, right?
My name is Shubir Banerjee.
Then who is Jayanto Banerjee?
he may be taller, but he's younger brother of Mr. Shubir Banerjee.
So though both of them are, they appear with the name.
No.
No, I'm not on that.
Yes,
I'm
yes, yes.
to your personal.
Mr. Jayanto Banerjee is the advocate on record.
Whatever it is.
Yes.
Whatever it is. But now I will have to keep a separate register. When will he file the paper book?
I will file.
When
I
will
will
you
file.
file?
Within 15 days, I will prepare the paper.
The learned advocate representing the respondent claimant is to file the paper book by 8th of September. Next date be fixed on 8th of September. Mr. Singh, you assist him in preparing the paper book on 8th of September itself. We'll finish it up. If it can be, I'll dictate the order.
Yes, yes, yes. My lord is fixing it up on
8th September.
8th September. I'll try to finish it off.
Your lordship, may I give the cross appeal number, your lordship?
The learned advocate representing the respondent claimant submits to have filed a cross appeal.
160 up to 2024. 160 up to 2024.
The department is directed to place records of the cross objection as aforesaid along with that of the main appeal.
ওইটার ক্যান আছে 107 ক্যানটা তো
Lord, 105 is the insurance appeal, 106 is cross objection filed by my learned friend, my lord, on behalf of the claimant. On the last date, my lord, since they have filed a cross objection, this condonation or delay application was not there with regard to the cross. My lord asked them to file the.
we filed the can application.
They have filed. They say that they have filed.
579 days delay.
Three, four, five, six, seven. Who will prepare the paper book?
The paper book has been already been filed earlier.
Cross objection. আচ্ছা আর একটা নিয়ে নাও 93
93.
93 রেকর্ডটা দাও তো এটা বলছি next date prefix on 17th of November
17th of November.
এটা
Get put
105
Publish.
ঠিক আছে
93 ডাকবে মেবি ডাকবে বললো
okay. 3 to 11 now who will prepare the paper book? Have you filed the
Yes, statutory deposit I have filed. The stay petition is can 1, Lordship. I have not deposited the award itself.
Achha, 4 weeks he is there?
Yes, madam. I filed a vocalatno.
Lordship, this is the statutory deposit, receipt copy of the statutory deposit. On the next occasion, I
Who will file the paper book?
Lordship, the trial court record has come. Kindly give the lip.
You will file the paper book?
Yes, Lordship.
The learned advocate representing the appellant insurance company intends to file the paper book and the same is allowed. Next date, 18th of November.
On the next occasion, I will file the affidavit of service because the India Post website is down. I could not collect that much.
Lord, 107 is insurance appeal on the last date, my lord, the stay was made absolute. Lordship, my lord, directed my lord's officer, my lord, to serve it upon the respondents, my lord. Through the administrative service was, my lord, directed to be made.
Then who is he appearing for?
Well, I am appearing for the claimant, my lord. Like appearing for the claimant led by Mr. Ashik Mondal, my lord. And then I have filed one cross objection that needs to be checked.
When who has filed the wakalatnama then?
My lord, the wakalatnama has been filed, my lord.
Who has filed?
Mr. Mondal, Ashik Mondal, my lord.
He was supposed to come from today.
My lord, we were expecting that he would join, but the situation has worsened, my lord. So he needs some time, my lord, some more time, my lord, to come, my lord. Deteriorated. Some more complications has arisen, my lord. So he needs some time, my lord. Till then, my lord, I need to assist your lordship, my lord, in some of this. Where
Who will file the paper book?
Lord, my lord, in front will file the paper book.
we shall file. And the cross objection may be checked, my lord.
Mr. Singh, your stay has been made absolute.
Lordship, on the last date, yes, it was, my lord. That was on 13th of May 25. Stay
The
was
learned advocate representing the respondent claimant intends to file the paperwork and the same is allowed. Next date, you fixed on 20 November.
20 November.
The matter cross objection may be
Paper book.
Lordship.
cross objection may also be tagged, my lord.
The learned advocate, you should have told this earlier.
My lord, I was telling my lord, so somehow my due to my
Advocate
timidness may not be
representing the respondent claimant submitted to have filed the cross objection being
112 of 2025.
got 112
2
Two?
112 112
of
2025 of this year.
2025. The department is directed to place a case record of the cross objection along with that of the main appeal on the next date.
Blessed to my lord.
Deeply obliged.
My lord, 116 is insurance appeal. My lord, pursuant to my lord's earlier direction, my lord, I have secured the entire compensation amount before my lord's court. May I file the challan? My lord, due to this server problem, my lord, this affidavit of service note is not ready. Lordship will kindly grant me 2 weeks time, my lord, to pay my affidavit of service.
This is the statutory or the
This is the balance amount,
balance.
Lordship. Pursuant to my lord's order dated 13th of June, my lord, I have secured the entire compensation.
And so your stay is to be made absolute?
Made absolute, my lord. And Lordship kindly grant me liberty to file my affidavit of service on the next date.
None appear to represent the respondent claimants. Was it served?
My lord, it could not be so. My lord, my noting is not here. Lordship will kindly grant me 3 weeks time, my lord. My lord, GPO is also, my lord, not taking up, my lord, this registration, this registered post, my lord. One at a time.
Next date be fixed on 19th of September
19th of September.
for filing affidavit
Yes.
of service.
Grateful to your lordship.
Orders are 10 মিনিটে কি হবে?
Yes, sir.
United India Insurance Company.
Lord, I have asked my clients, my lord, to check up this old record because these are, my lord, old records. 2007, 2008, 2009. And, my lord, most of them have been filed, my lord, the records, my lord, what is appearing today, 52 matters before your lordship. My lord, most of them are by the claimants, my lord. This, my client, my lord, could not find this Chameli Mishra 167.
Now who
was
was
his-
recorded? দেখো তো advocate on record কে আছে?
So, my lord, if I could at least get the name of my lord, these matters your lordship intends to dispose of in the month of August itself. Is there any, my lord,
That is
anything,
this is what they are saying. I mean,
this is what my lord is trying to, to finish it off in August.
huh? Where is Mr. Bonik?
Lord, Mr. Bonig is court number 6.
You take note of this matter. This is your matter.
My lord, my clients are, my lord, they're trying to reconcile, my lord, to find out, my lord, as I told me on the last day, there were 3 days off, my lord. So,
But let the claimants also be there.
yes.
From the Wakalatnama itself, we'll find out. Mr. Bonik for at a list বানালে হয় না 10টা
My lord, my lord, sorry.
It's your matter. Where's Mr. Bonik?
Mr. Bonig is, my lord, court number 6.
Then you take note of it, right? 167 FMA, Mr. Bonik is there as advocate on record. And wait. ওটাতে দেখ যে ইয়ে কে আছে রেকর্ডটা তো বার করে দেখতে হবে
এগুলো ডিসপোজ করাবেন জজ সাহেব আদার সাইডের সঙ্গে কথা বলো কি আমি তোমাকে পরে বলে দেবো হয়ে যাক
Or next date I will the brief.
রেকর্ডে নেই? One 171 is
Yes, Lordship.
Mr. Roy.
Yes, Lordship.
And who is your other side?
So I don't
Sumiran Odhikari, do you know him?
know. Sumiran Odhikar is the owner name.
Owner name?
Owner name. Whether insurance company appear or not, that I
But
insurance company.
what is the name of the insurance company?
United. এটা দেখো তো রাজদা 171
দেখবো এখানে তো নামই নেই না বুঝতে পারছি না।
ইউনাইটেড
এখন দেখছি Milord, there are 4 public sector undertaking. Milord, during these times, Milord, mainly out of these 52,
One.
Bolo.
And who else are there? Mr. Ashik Mondal must be having.
No, my lord, it was not in 2017.
He was not there.
No, he is coming by in 2017.
He's coming 2017.
My lord, nearly 10 matters would be deleted because they don't concern to this, my lord, insurance matters.
No,
I could have just given
maybe,
example
but
after-
either way.
Your Lordship, Lordship, in item number 70.
Yes, it has been dismissed for non-prosecution.
So, Lordship, I was there from 2. I had
But then when the matter was called, you were not.
tried to inquire, but it shouldn't be done. Your Lordship, I filed the work on the plan. Before, as your Lordship directed me, file it by 1 p.m. I have done the same. I was waiting here till 3:30. Matter was called on at around 4. It is my mistake. I had to leave for some reason. I immediately rushed in when the matter was called on. But
You did not rush in immediately. You came after half an hour.
Your Lordship,
Yes,
so there was a delay. I was
you came after half an hour. That too after 4:30.
my unconditional objection.
You go and call the other side advocate. He had gone to call you, but he could not.
It's the same as left.
Milord, item number 2, Milord, original site, Milord. Milord, I was not feeling well, Milord. I couldn't appear before your Lordship, Milord. Lordship,
Yes.
please to dismiss the matter, Milord. Kindly, Milord, kindly, Milord, adjourn the matter, Milord.